Okay, council and ladies and gentlemen, we're going to go ahead and begin our meeting at 5 o'clock straight up, a special meeting for Tuesday, May 26, 2026. Just a little bit of housekeeping before we get started. This session is going to start with a briefing from our Texas Municipal League Attorney Jim Jeffries, who's here, and our City Attorney Robert Hager. So they'll be talking a little bit about why we're here and where we might be headed. And after that part, we will enter into deliberation, which will give you an opportunity to speak and maybe ask some questions if you have questions for the attorneys. So once we get to that point, I'll announce it so everybody will be clear. Now, in the meantime, after that, we have citizens input, which is a session that many of you are aware of that allows you to speak for up to 2 minutes, but we can't comment back. So if you signed up for that and you'd prefer to speak during the deliberation, let us know. We'll be asking in the audience who'd like to speak, and we have a floating microphone that we can pass around. And if you prefer to come to up here to the podium, feel free to do that as well. We want to make sure we get as many questions answered as possible. So with that and no other business, we'll move into the briefing. Item A under briefing and deliberation, and attorneys, who's going to begin? All right, Mr. Hager.
Mayor and council, and those of you in attendance tonight, citizens of the city of Duncanville. You are familiar, I believe, with the Life School location in Cockrell Hill and Daniel Dill Road at the southeast corner, and that proposed development that was brought before the council for a council meeting on July 15th, 2025. And after that council meeting, Life School, the applicant in that case, after being turned down, sued the city of Duncanville and sued individually all the council members. And so that's what we want to talk to you about tonight, where we are with this. And we wanted you to understand and hear this from us before anything else happens, what the status of that lawsuit is, where the city finds itself, and what we think will happen. And we will later talk to the council tonight about the possibility of settling this matter. All right, back in late 2022, early 2023, that property that we're talking about at the corner of Cockrell Hill and Daniel Dill Road was bought by the Life School. And prior to them buying that property, they had come to the city and said that they had visions of putting a school there. They didn't specify what the school was necessarily going to be at the time, said that they would like to develop a school site on the property and that the rest of the property could be committed to commercial use immediately adjacent from Cockrell Hill, moving, I believe, eastward, and that the frontage would be possibly dedicated to commercial. At that time, they had the property under contract. It had not closed, and they asked the city whether they would, if they had any objection to us or to them possibly developing the site. And there wasn't a lot of specificity. At that time, the council said, no, we don't have a problem necessarily with that. And ultimately, they purchased the property. In 2024, they filed a zoning application seeking to put a high school and junior high on the property and not to develop the property for commercial usage along Daniel Dale Road, but had taken that part out. They sought a specific use permit, which is required by our zoning ordinance at that time. And many of the things that they had proposed were problematic. During the summer of 2024, that application was withdrawn. And they filed a new application in the fall of 2020, I believe it was in the fall of 2024, moving towards 2025. And it's the proposal that we have before us now. At that time, it was reviewed by staff. And at that time, when that new application came, we were concerned, and we're concerned for the reasons that I'm going to talk to you about tonight. And we talked to the citizens that live in that immediate vicinity. I believe it was Dr. Sasser who brought a number of people that lived in that neighborhood to the city, and we sat in the briefing room, and I'm going to read you what I told you then. It is our understanding that the Planning and Zoning Commission for the city has requested a legal opinion on the zoning rights of public charter schools in Texas, including the Life School, an open enrollment state charter school. Specifically, the commission seeks clarification on what the city can and cannot regulate when it comes to zoning, location, building standards, and other site development matters for such schools. Texas law requires the open enrollment charter school be treated the same as public school district for zoning and land use purposes. And under section 12.1058 of the Texas Election Code, open enrollment charter schools must be treated as same as a traditional public school district when it comes to zoning, permitting, architectural design, landscaping, traffic analysis, and other related site regulations. This section also makes clear that a political subdivision may not take any action that prohibits an open enrollment charter school from opening in a public school campus, education support facility, athletic facility, or administrative office within the political subdivision's jurisdiction. In the City of Addison versus Dallas ISD, the court concluded that a school district may place any school facility within an area zoned residential unless the school district's action is unreasonable or a nuisance per se, because of the school district's authority is paramount. Our responsibility, our regulations are second to the school. While the city may not impose zoning regulations to prevent a school from operating, it can impose reasonable regulations related to safety and health codes. In Austin ISD versus the City of Sunset Valley, the Texas Supreme Court emphasized while a school district could be subject to municipal safety regulations and building codes, a municipality cannot use its zoning power to exclude school buildings from its boundaries. Similarly, the Attorney General has also clarified in GA 967 that cities may enforce land development regulations and ordinances for aesthetic and maintenance of property values as long as those regulations do not prevent a school district from reasonably selecting a building site. That's the law in Texas, period. The Sunset Valley case is 70 years old. The Addison case was decided in 1982. I happen to know about that case because I was the lawyer. And so I've been here and done that. And so that's the law. Whether we like it or whether we don't like it, that's the law in Texas. And that's the law that governs their application, and that's the law that was presented at the time, or that was the law at the time this case was heard by this city council. Despite all that, the council turned down this application because of, as I recall, there was an issue about traffic, and there was an issue about the height of the buildings. The traffic issue's been resolved. And what the city has done, at the night of the hearing, as you recall, they had a traffic study. We did a peer review. This council was not happy with the peer review. They wanted their own traffic study. Well, we've done one. And from a reputable engineering firm in the Dallas-Fort Worth area, Fries and Nichols. And their traffic study is the same result as the school district's traffic study, so the traffic mitigation plan is no longer a reasonable impediment to this development. You may not like it. I don't like it. I don't think anyone up here likes it. But what I did when I became a lawyer, and what they did when they became council members, they took an oath to uphold the law. Now, we'll get to it's okay to challenge the law, don't get me wrong. Lawyers do it all the time. But I have an obligation to follow the law as well, once that law has been decided. So that's where we find ourselves this evening, because we were sued and they claimed that our denial was a denial of their property right as a property owner. You have property rights as owners of your property, but the people that bought that property also have property rights, and they seek to put a school there. And the Texas Supreme Court and the Fifth Circuit Court of Appeals, of which Duncanville is a part, have said the decision where the school gets to place their facilities is the school districts alone, and the city does not have the authority to keep them from selecting that site. So that's one thing. The site's been selected. They do, however, have to follow our building codes, our setback requirements, the massing of the building, other health, safety, and welfare regulations, the traffic. So when the council heard the case and they had questions about the building height and about the traffic, I believe they were within their ballpark. But those issues, as a result of the litigation, are now gone, because the height of the building is 35.5 feet. The height of the football stadium measured from grade is 35.5 feet. And that's 2.5 stories, and that's what's required in the S13 district, which is what this property is currently zoned as. Now, I'll let our litigation lawyer that TML, Intergovernmental Risk Pool, has appointed to defend us in this case, and he's going to talk some more about constitutionality questions and about some of the legal questions that we've litigated for you as your representative on this denial. But where we find ourselves now is in a weakened legal position than what we had when we denied the case. And it wasn't all that great to begin with. And I told you all that we may come here to this day, and now this day is here. And I've always been honest with you when I told you they get to decide where the school gets to go. We don't get to make that decision, because the Texas Supreme Court has told us that decision belongs to the school district. The legislature passed the education code for charter schools and said they enjoy the same benefits as a public school. I'll argue that all day long with you, that there's no accountability for a state charter school. I think it's awful that the state gets to decide where the school is, to the detriment of the people that live in the community and pay the taxes. And I'm with you 100%. But the Texas legislature took that away from us. Now, there is some constitutional. Mr. Cooks, what can I do for you?
So the mayor, City Council, City Attorney, would you repeat the first case you said, Addison?
Yes.
Mark,
The city of Addison versus the Dallas Independent School District. And I can tell you what the facts are. And the facts are, that's where Lowe's athletic facility now sits. That's actually in the city of Addison. And they also have a bus barn on that location. And it was challenged, and they made the case, and the court agreed with them, that it was a facility necessary for the educational mission of the school district, and they get to decide the uses. And Lewis Nichols, who the park's named after across the street, he and I tried that case and argued at the Fifth Circuit Court of Appeals and lost based on Austin Independent School District versus Sunset Valley. Yes, sir.
The traffic study that was done, good evening, everyone. The traffic study that was done, what was the boundaries of that? Was it just to Daniel, out to Daniel, to Daniel
No,
Dale?
it was all of Daniel Dale and all of Cockrell Hill out to
All the way to
67.
67? Okay, thank you.
Yes. One of the things you'll find, and I'm sure there'll probably be an open records request for it tomorrow morning, but the study does, in fact, indicate that that intersection at, if I'm reading it correctly, that intersection at Daniel Dale and 67 is rated E, and it's just like school. E's not good. It's deemed a failure. And it's really, I can't ask the school district to fix it because it's beyond the scope of their property. I can only ask them to fix the things that they are immediately contiguous to or adjacent to. Now, they have agreed to do some restriping, I think it's eastbound, so that there's only a turn lane to go back down the service road. And they've agreed to do that. They've agreed to put the warrants and to make some adjustments at the intersection of Cockrell Hill and Daniel Dale. That was their mitigation plan that they offered. Our Friesen Nichols also said that those were appropriate and warranted in their professional opinion and should not, I don't want to say make it great, but it would improve the traffic. And I know about traffic studies, and I know that it's engineers theorizing what should happen if people follow the traffic law, but people being people, they do things all the time that traffic engineers are never going to agree with is appropriate conduct for them to operate their vehicles. But having said that, it puts us in a weak legal position because our own engineers have said that it's appropriate mitigation for the school. Another question?
This is a question for the attorney as well, but it's broad. I'm just saying that in advance. This meeting is at 5 o'clock rather than the normal time that it is. And so a lot of us, I know me personally, I took off till I could make sure I was here, only to get here at 5:01 and told me I couldn't read my comment because I was 1 minute late. So it is my hope that with this extreme conversation that we're having with the public, that those that would like to be able to speak, like myself, get the opportunity to speak and we don't get punished because this meeting is at 5 o'clock when we took off time and we were 1 minute behind. So just putting that out there.
Sir, I'm going to respond to that. And I apologize that you didn't hear the opening remarks. After this briefing by our attorneys, there's going to be a deliberation, at which time, outside of that card that you normally would have filled out, any questions you have that you want to ask of the attorneys, you can feel free to ask that question. We'll open that up right after the briefing session where they continue to explain how we got here tonight and why we're here.
Understood, and we'll be able to address everybody because that would be something we would love to have.
Well, when you say everybody,
Meaning, or during the open speaking part where we typically fill out a card,
right,
will we be able to have that opportunity? We would love. We know this is tough, and I'm just saying that in advance. I respect everybody, for the work that you do. I just don't want to be punished for 1 minute behind.
You're not being punished. You'll have a full
Thank you, Mr. Mayor.
opportunity to talk.
Thank you, Mr. Mayor. I appreciate that.
All right. So, over the course of the time period since the initial filing of the complaint, our ability to file the answer, to do the discovery, Mr. Jeffries, who's here tonight, handled all that. But in the meantime, we've been defending our position, but they have been making corrections to their application, which that's just what happens during litigation. Okay, well, you don't like that, we'll fix it. And so as a result, we got to the point in mid-April where we pointed out things we didn't like, they fixed them, and at that point, we had to sit down with them and discuss where this was going. I'm not going to, I don't want to take Mr. Jeffries' time and his explanation of where we find ourselves. But I need you to understand they are threatening to sue these people for monetary damages. Not the city, these people. That's one thing. Two, the city for damages. And to pay for the delays and them wanting to get this built last year, not this year, the increased cost of construction, pay all of their lawyers' fees, which are well over 6 figures. And our insurance, I can say this, he came for this, is limited to $150,000. And it's called an eroding insurance policy. And what that means is every dime I spend to defend this is less money we have to pay damages in the event we are found liable. Now, the damages we're talking about are not 6 figures, they're 7 figures, millions of dollars. And it's millions of dollars of our treasury that's supported by your ad valorem taxes and the sales tax of this city. I know that this is your home. I live behind a Kroger. I wish it wasn't there. And I realize this is tough, but it's no tougher for you than it is for me to have to sit up here and tell this to you, because I am empathetic to the plight we find ourselves in. We didn't ask for the school to be here. They asked to be here. They have the legal right to put it there. So we've done the best we think we can do and sustain in court by negotiating a settlement. It meets all the requirements of the setbacks. It meets the massing. It meets the height. They've agreed to put up a screening wall on the southern boundary near where this football stadium is going to be. They've agreed to abide by the UAL rules or UIL rules with regard to using that facility in the time. But you have a question.
Thank you, Mayor and Attorney Hanger. Question for you is zoning guaranteed? So I'm listening to this and I understand that they were already, able to build a school, but they requested zoning changes. So that's the primary reason why they came, not to build the school, but for the zoning changes. Was that guaranteed?
They went through the zoning process, and the reason they went through the zoning process, initially there was some request that the school needed to be higher than it is now in the plans, that the football stadium would be larger and higher, and they would need relief from the zoning regulations that were in place. So they asked for a plan development or a special use permit, and the first time special use permit, second time a plan development, because we have the ability to relax the rules on height and setbacks and facilities, buildings under and or uses under that zoning ordinance. And so they filed the application. They could have just come and gotten a permit, but they would not have received any concessions with regard to height, setbacks. They could have put everything a lot closer. So by going through the process, I don't say a great deal, we got a better deal, because we made them move the stadium further away from the the neighborhood to their south, moved it a little bit, moved it up a little bit, and now they've agreed to put up a screening wall. We asked them to berm it, but that didn't make any sense because the way the property drains, it may have actually made it worse for the neighbors to the south of the property. So we got, and yes, sir.
Thank you, City Attorney and Mayor. City Attorney, if you knew all of this ahead of time, Why didn't you inform the council before we went through all of this? That's question number one.
I did.
But
I read
That's
this
not what we
letter.
heard. So
I
let me
read this
finish.
letter.
Let me finish.
All right.
The second part is when you talk about suing, being a former city council member, as you just mentioned, TML is not like they're going to personally have to pay out of their pocket if they're sued. That's where you just mentioned TML covers the city, and I'm not an attorney, so I don't know it all, but that's where TML come in at, Texas Municipal League, for those who are not familiar with it. And so it's not like they're getting sued personally.
Yeah,
they're
are, 'cause
representing
they're being
us.
sued in their
They're getting
individual
sued
capacity.
personally, but they're covered by TML. The other part is, I hope you provide it to the council, because I'm reading something differently from the Addison and Dallas dispute. I hope you provide with the council something in writing versus verbally. I know about the two suits, because what I'm reading is totally different than that.
Well,
But I'm just hoping you provide
I
it to them
defended
as well.
the city of Addison.
I understand, but that city of Addison piece was never publicly said in this type of environment. And so I was just wondering, this is my first time hearing it. Maybe the council heard it before. I've never heard it before from you. And so I was just asking from this point, why wasn't it brought up to the public at that point as well, to get it covered? Thank you.
Well, when I give legal advice, as you know, Mr. Cooks, I give it to the council in closed executive session.
That's not legal advice, Mr. Attorney.
What's not legal advice?
You just said that was public. You said
No,
it
I
was
didn't.
public about the Addison and the Dallas case. That's public information. And if it's public
It's
information, that's
reported-
not giving them legal advice. But I won't argue back and forth with you. I just make my statement.
No, I need to understand what you're accusing
you
me of.
understand it. You
No,
understand
I
it,
don't.
city attorney.
I don't. All court cases are published in Westlaw. They're available to whoever can find them.
Well, I just found it, I didn't read it the same way, and I'm not an attorney. I hope an attorney will address those two cases that you just mentioned.
What about it? Then tell me what you don't, how you read it
I'll
different.
print that for you, Mr. Attorney.
I don't need it printed. I know what the case says.
Well, if you already know, I'm going to explain it to you. You're an attorney, you know. So let me stop. I'll stop from there.
Any more questions?
Okay, at this point, okay, go ahead. Go ahead, sir.
Yes, Mr. Hager, you said earlier that the life school was subject to some sort of school district. Could you clarify that?
No. What I mean to say is they have the same standing as the Duncanville School District within the jurisdictional boundaries. So I can no more tell the Duncanville or Life School where to put their schools than I can Life School.
And that's part of the statute, is that what you're referring to?
Yes.
Now, has that statute ever been challenged as applied to a charter school?
We're going to talk about that.
Okay. And so my question is, and my problem is with the charter school, they are quote unquote a school, but they're not subject to the same democratic controls of a school board. And so now we have an entity who can come into our community, isn't subject to the democratic controls that we have in the form of a school board, and then also have essentially customers who don't live within this neighborhood. And so you guys are completely indifferent to the nuisance that you guys are creating.
There's no one from Life School here.
Well, that's unfortunate.
Yes, I understand, and we've pointed that out, and that was raised, as you will hear, in the litigation. And he's also going to tell you what the assessment of it is, because who did pass it are your state representatives and your state senators. They passed that statute. Well, Senator West, I know not everyone voted for it. Yes, sir.
All right, it was passed by the legislature.
Yes, sir.
Don't say your state senators and state representatives
Fair
passed
enough.
it because
I
we didn't.
apologize.
Okay, thank you.
Okay, before we go on to any of the questions, because we were in our briefing portion, and rather than fielding any more questions at this point, I want to go ahead and have Mr. Jeffries come up, because he's going to fill in a lot of the blanks to questions you may already have and that you may not need to ask after he explains it. But you will get an opportunity to ask more questions.
Mr. Mayor, before, I know this question does not have to do with that attorney, it still has to do with the legal governing body for the city. So I do want to
Okay.
ask one last question. if you don't mind.
Well, okay, last question, because we need to go on with the rest
Last
of our
question is
briefing.
fine. So if we set, if the precedent has been set by the city of Duncanville for all of the noise ordinance that we've issued citations to, for all of the business owners that we've said no to because you could not height to the building, are we also setting ourselves up for further suits?
Now, this is peculiar to the school district, Mark. It's not peculiar to anyone. The school district has that Supreme Court case, and they've got the legislature telling us that we have to treat state charter schools as if they were our school. This has nothing to do with a business or a private ownership or even a private school.
Okay. All right. With that, Mr. Jeffries, are we ready? Do you want to speak at the podium?
I'd like to speak.
Sir, okay, all right, let's, okay, we're past that point. Sir, no.
Mayor, I'd like to call a point of order.
Yes, sir.
The mayor runs the meeting. He needs to control it.
You will have time to ask all your questions, sir. We will get to your questions, but right now, we're going to go ahead with the rest of our briefing portion from our Texas Municipal League attorney.
Good evening. My name is Jim Jeffrey, and I'm the attorney that's been hired to represent the city of Duncanville and the individual council members and mayor who are all being sued in this lawsuit. And they're being sued personally, and they're being sued in their official capacity as well. And I think that's very important to keep in mind, that these elected officials who give their time serving the city are defendants in this lawsuit. I'm going to echo a little bit of what City Attorney Hager has said about some of the key issues in this case. And the key issue in the case is really, does a city have the legal authority to tell a school that it cannot select a location for its school, its campus, and other structures that are considered integral to the school's operation and educational mission? And the courts have determined that buildings, athletic facilities, if the Life School were going to put in a bus depot and parking facilities, those have all been recognized by the courts as integral to the mission of education. And the Addison case that Mr. Hager cited and relied upon has been cited many times in disputes between school districts and cities. Now, charter schools, under the statute that our legislature has adopted, charter schools are entitled to the same status as a school district for purposes of these land use restrictions and regulations and the limitations of what a city can or cannot do. And I think that's critical to keep in mind, because the charter school, which I agree with you, doesn't have the same method of operation. The people that run the school and are on the board of these schools are not elected officials. And I raised that in the lawsuit. And I raised some other issues about the statute on how these disputes are decided, and that's under Local Government Code, Section 22.902. There's a provision that's little known, but it basically states when a case like this goes to litigation and a suit is filed, there's a procedure whereby the And sir, if you're Googling that statute, I might have, it's 22.902 or maybe 912. I'm sorry. I've slept since I looked at it last. But the local government code provisions set a process for how these kinds of lawsuits are resolved, and it's an expedited process where the judge appoints an arbitrator, and then the arbitrator makes a decision, and the parties are bound by that decision. So when I raised a challenge in the lawsuit to the statute used on how these procedures are decided, instead of even letting a jury decide this, and certain kinds of issues in a lawsuit like this involving court orders and injunctive relief, those are decided by the court. The factual basis that the court uses to make those decisions are often decided by a jury, citizens, people who serve their civic duty by being put on a jury. Well, the statute doesn't give a jury a role in this kind of a case. And so when I challenged on behalf of the city and the individual defendants the statute for how the decisions are made, and then did not file the challenge, but when the Attorney General got involved because of the challenge that I raised, I had discussions with the Attorney General about the underlying fundamental statute that creates charter schools. And everything that one of the gentlemen in the blue coat pointed out is something that I discussed with the Attorney General. The charter schools are not run by an elected school board. They are a group that gets together, forms the correct kind of legal entity under, it's called a 501c3 tax-exempt entity, and then they go through a process of review with the Texas Education Agency, and if the agency approves their self-created document, and there's a few other steps, but they get the status of a public school, and the statutes the legislature have adopted give them the same status as if they're a school district for these purposes. They even get access to taxpayer money. They even get access to the right to issue public finance bonds for building these improvements on their school district. So, frankly, in the lawsuit, we kicked over a hornet's nest by challenging the statute that creates this expedited procedure for resolving these kinds of cases. The Attorney General intervened in the lawsuit on behalf of the Life School, and the Attorney General and Life School attorneys, they, in effect, Attorney General intervened and basically supported Life School. And the Attorney General and I had an informal dialogue about what is the city going to file next. And I said, well, if I file a challenge to the underlying statute, I could not find any court decisions that upheld or struck down the statute involving charter schools getting this status as equivalent to a public school district. And the Attorney General said, yes, this would be what we in my profession call sometimes a test case. And a test case can last for a very long time, cost a lot of money, and there's, of course, risk associated with that. So I will say I've been a lawyer a long time. I know how to research. I feel comfortable with the work I did in evaluating what is the likelihood of a successful challenge to the statute that gives this school the same status as a public school district. And I think that would not have been a very likely successful challenge. In my view, the legislature was careful to, ma'am, can you hear me back there? Okay. In my view, looking at the statutes on how the legislature went about authorizing Life School or charter schools and defining them as part of the public education system, it's like the legislature had a checklist of the things that can be the basis for a successful challenge and tried to address all of those potential challenges when they pass the legislation. Now, I'm not saying it's wise legislation. I'm not saying I like the legislation. And I'm not saying that I think charter schools are always a great idea. They can be inconvenient because not only do they have the same equivalent power of a school district in this kind of a matter, but they're not elected. And so they don't answer to people like the citizens in this room. But that's what the legislature has chosen to do. The process for creating these life school-like entities, these charter schools, as I say, they have to first organize themselves. They have to adopt a plan of operation approved by the Texas Education Agency, and then the agency maintains supervisory review of their method of operation, their curriculum, their success rate, how they spend taxpayer dollars. And that's a state agency. And the decisions and court decisions on other types of challenges to state statutes involving whether the state has improperly delegated authority to private, either individuals or private entities, those are the kinds of things that are going to support the validity of that statute that authorizes charter schools to operate as the equivalent of a school district for these land use decision-making purposes. So that challenge, I think, would have been unlikely to succeed. It would have been expensive. And then I do want to chime in here, contrary to what Bob said, I'm perfectly willing to tell you how I get paid. I get paid by the Texas Municipal League under this eroding $150,000 worth of coverage. And in other words, every dollar they pay me and my firm is reduced from the amount that would be paid eventually to cover the lawsuit, cover the city, cover the individuals who are being sued here today. So the only person that would make money on the case if we fight the fight that would have likely not been successful, taken a long time, and taken a lot of legal fees, the only winner would be me. I'd get paid for fighting a fight that's not all that likely to succeed and take away protection from the city and the individuals who are being sued. And I don't do that. My interest when I'm hired, regardless of who hires me and who pays me, is I represent my clients. And my client is the city of Duncanville and my individual clients who are all elected officials. And everybody sitting up here, except for Mr. Davis and Mr. Koontz, our city attorney and city manager, they're all being sued over this. They face personal exposure, and the city faces exposure. And every dollar spent by the Texas Municipal League risk pool that goes to me takes away protection from the city and those individuals being sued. And they're being sued for doing their job and probably voting the same way I would have voted under the circumstances. So I think that's very important to understand. We got the Attorney General involved. They have what I'm going to call unlimited resources to fight this fight. And the Life School was making a challenge that if they were successful, they could have gotten not only monetary compensation if they proved that they really had lost money or that their property had been taken or diminished in value, that could have come out of the city's pocket. And they were claiming what I'm going to call a damage model that could have been a seven-figure, and not just $1,001 seven-figure, but several $1 million potentially. And the Attorney General was going to back them on that fight. And if they were successful in that fight, whether they got money, whether they got injunctive relief, part of the relief they were asking for, injunctive relief is when the court tells you to do something. If they were successful in their fight, not only could they have gotten money from essentially the city coffers, but they could have gotten their attorney's fees paid. Their attorney's fees, according to the lawyer who's the lead attorney on the case, were already pushing close to $200,000. And frankly, I'll tell you the numbers that we're talking about, because we've already shared with you the $150,000 of eroding or shrinking coverage. The amount that we've negotiated, if we resolve the case, is $80,000. And we're not we don't, at this point, if this deal goes through, it's not $80,000 in attorney's fees or damages. It's here's $80,000 plus some other factors that I'll talk about in a second. Yes, sir.
This is just a clarity question. The Attorney General. Is there any rule in actually stating the Attorney General's name? And if there's not, I would love for that name to be stated so that we all have that for the record.
Our Attorney General, who has higher aspirations, is Kenneth Paxton. And now he's got his subordinates and he's got his litigation group, and so he's not personally handling the lawsuit. A gentleman named Philip Smith is handling the lawsuit. And Mr. Smith is actually Colonel Smith. He's in the Army Reserve. Has been very diligent about the work done on the case. But yes, it is. I'm not hiding behind the name, but it's the Attorney General's office that we have to deal with. We all just refer to him as OAG, Office of Attorney General. But yes, Ken Paxton's the Attorney General of the state of Texas. He, again, might not be for long, depending on what happens. And, well, I try to avoid discussion of politics, but he's not running for re-election to that office. But yes, that is who's involved. And so the Office of the Attorney General, their attention was drawn to this case when I raised a challenge to the statute on how the case would be decided going forward. And if we resolve this case, it's going to be resolved, frankly, using the judge as the resolution to the case, and the judge is an elected official, unlike an arbitrator that the statute contemplates. So that leads up to where we are, and the resolution of the case, if the council approves it and directs me to go forward, I can spell out the concessions and clarifications that were probably the reasons for the council turning it down at the first go-round and leading us to where we are today. The height of the stadium was unclear in the package that was submitted to the city. And what the concession is, just as Mr. Hager stated, it's going to be measured from grade about 35 and a half, maybe 36 feet. You know, I think 6 inches doesn't matter one way or the other, but it is consistent with the number of stories and the height that city code allows. And the stadium structure itself is actually going to be lower than the maximum height allowed, which is roughly 35 or 36 feet. What is it, 2.5 stories, Bob? Yes, sir. Yes. So the height of the structure itself is approximately 30 feet from grade. The additional height of roughly 4 feet is because the height, the tall part of the stadium is the press box, and the press box is going to have a guardrail around it so that photographers and videographers that want to get on the roof for a better vantage point don't fall off. But the structure itself is roughly 30 feet, so several feet below grade, and the height of the guardrails pushes it right at the limit. So that's been clarified. The stadium will house approximately 1,000 people total, That's been clarified. The masonry fence or screening wall that's been discussed, that is going to be, as Mr. Hager stated, it's going to be on the property lines that are adjacent to the residential properties. Some of them are here in Duncanville and some of them are next door in DeSoto. But along their property line, there will be an 8-foot tall masonry fence. And Life School has committed to spend approximately $500,000 to build that. As Mr. Hager pointed out, the berm won't work from an engineering standpoint because a berm traps and holds water. I grew up in New Orleans. I know all about berms. We call them levees a lot of times. And water's not supposed to go through a berm or a levee. Whereas with a masonry fence, they can design them, and they have and will design this one so that water can flow underneath and it won't trap and back up onto the residential neighborhood adjacent to the property. So the wall will have either, we've all seen them, the plastic PVC pipe along the base of the walls that they build around it where water can flow through. Sometimes you refer to them as weep holes, or sometimes they raise up the bottom row and there's a steel support holding up the fence and water can flow under. So it's probably, in my opinion, better looking than a dirt berm, and it allows water to flow through without trapping it in the neighborhood next door. Sir, do you have a question?
I do. Thank you, Mr. Attorney. Let me ask one other question. We keep talking about the school itself. I think most of our concern is the stadium. So would you clarify, are those two separate items? Can it be two separate items? Does the stadium must come with the school? Or because I think the SUP was stating that they need the SUP for the stadium. So would you clarify that for the stadium for us, please?
Okay, I'll try to break it into pieces.
Okay,
to make sure I cover everything.
And I have a question after that,
Yes, sir.
big piggyback.
You're gonna wear me out, I know.
You paid all that big money.
Yep, well, and you're taking money away from the protection that these people get. But, okay, so let me talk about it a piece at a time. As I understood it, and some of this Bob may have to chip in because he's more familiar with the city's codes than I am. But I will try, and Bob can correct me, Mr. Hager can correct me. So under the specific use permit or special use permit procedure, under our zoning code, the school is allowed to exist. And if the school had pursued that procedure and they initially were going to and then backed away from it, they would have been entitled under our own zoning to be located there. Now then they would have had to meet criteria that we can impose through part of the permitting process, and it gives flexibility both sides, and that can be the SUP process can be used to effectively take care of things that might need variances. Now, as I understand it, and I'm looking at this historically because I got it after it was already in lawsuit. But as I understood it, the next approach they used was seeking a planned development. A planned development, they don't get the benefit of the zoning requirements of a specific use or SUP process, but you can do some of the same things with a planned development as far as the city can work with the property owner, and that would be the same whether it's a school or a commercial development. Work with the property owner to try to have some give and take about how we want this whole project to be built. My understanding from looking at all of the plans that I've had to historically review is that the stadium has always been part of what the school wants. And so the fact that there were some issues related to the stadium, because the stadium's potentially it's going to have traffic after hours and be noisy and all the things that I wouldn't want to live next to either. But the stadium is the source of, I want to say, when I go through it, the list of things, the clarifications, the stadium was the source of most of the concern that was going on at the time the plan development was turned down by council. So that was really the focus of what we've talked to Life School about and tried to get clarification about. So they're really tied together, is my understanding, from day one. Does that take care of?
Yeah, I did take care of the question. The last question with that is that, does that also mean that they're exempt from any noise ordinance? I know Duncanville has that noise ordinance, so that means they're totally exempt. They can just do what they want to do because they're a charter school. And so, whereas we have a noise ordinance here in Duncanville, it'd be no need for me to call and say, I can't hear my own home. So you're saying they're exempt from that as well?
No, I'm not. But I will also tell you that noise ordinances are one of the hardest things to enforce. In addition to being hired to defend lawsuits for cities all over, frankly, all over Texas, except West Texas and Deep South Texas, I also served as a city attorney at 2 little bitty towns in Tarrant County. And so I'm familiar with how you enforce or have some difficulty enforcing noise ordinances. Basically, you would have to show that the noise is unreasonable at a given point in time and under the circumstances, almost have to catch them in the act, so to speak. Now, it's easier if there's a football game going on and they're blaring stuff on the loudspeaker and so forth and so on. But I think the enforcement would have to rise to something that's called in the legal world a nuisance. And we all know what a nuisance is. I mean, I got 3 sons. I know what a nuisance is. But a nuisance legally is something more burdensome than what your sons usually put you through. It has to interfere with your normal use and enjoyment of your property is a broad definition. And the outburst that happens because somebody got a touchdown might not qualify as a nuisance, but it's not that the city has 0 tools to use against them on noise ordinances. We've got the same tools that we would have whether they're a private entity, a private business, holding a festival or an outdoor concert. If it's too loud and it's one of those, you know it when you see it, you can issue a ticket and then they can take it up in municipal court. And then from there could be further enforcement action. So it's a tough thing to enforce, but it's not unenforceable because any school is subject to any restriction and regulation that keeps them from being a nuisance. In fact, if it's extremely hard to show, but you could theoretically say, well, having a school at that location operates as a public nuisance. Man, that'd be tough, and I don't think it's ever been successful. But nuisance is one of the areas where courts allow regulation of schools, school districts, and charter schools. Yes, sir.
One of the things I would love for you to speak to, because this helps us to be able to understand something that right now we're not understanding. And the context is I want to thank our state senator for being here and also thank those that voted correctly on the last time that, in the way that the citizens were asking. So the part we're having a hard time understanding is how can anyone individually be sued for making a vote that is in line with city ordinances, regardless of whether or not they themselves can then find a loophole to get around it? How can an individual be sued individually for following city law? That's a hard thing for us to get grasp, because that's the main thing we want. We want our people to represent us. So I would love for you to speak to that. I'll have questions later, but that can help us if you can explain that part.
If I can explain that and convince you I'm right, I wish you'd be a judge.
The legal concept that somebody can be individually sued for doing what they took an oath to do.
Yes, sir.
We don't understand that part.
Okay. That is a very hard to answer question, and that So let me try to explain it to you, and let me tell you, it's something that courts wrestle with and have trouble with. So when I explain this to you, and I'm gonna try to be fundamental, it's not because I'm trying to talk down to you, it's because judges have trouble with it too. And they're theoretically educated in the law. Okay. So there's a defense, there's a couple of defenses available to these individuals. One is official immunity, one is legislative immunity. They are legislators. So when they're performing a legislative function, they are entitled to absolute legislative immunity. And that's comforting to know. So then, as part of determining, are they entitled to legislative immunity for their actions, you start with asking, were they performing a legislative function or something else? So the easy one is passing an ordinance, that's legislation. So if they vote on an ordinance, that's legislation. Granting or denying a planned development permit, I would contend, is likely to be legislative because you're effectively amending your zoning ordinance. So the fact that they have a potential immunity defense is something that I didn't overlook in the case, but then you get into other functions and the court could decide, well, that isn't legislative, and therefore they might be not entitled to legislative immunity for something else they might have done. So some of the accusations that are made in the lawsuit, which I don't think could be proved, but would have been expensive to defend, some of the kinds of things that the individuals are accused of were stepping outside of the legislative role, that they were turning down life school and maybe agreed somehow improperly to turn down life school, not sitting at the podium voting on a piece of legislation, doing something else that may not be legislative in function. There, none that I've come across. I mean, I'll be candid with you, but again, part of the lawsuit process is there's a process called discovery, and you serve each side with written questions that they have to be answered. Documents have to be produced. There's a disclosure process where disclosure has to be made. And at tremendous expense to the city, and I'm talking about paying employees to do a lot of work in addition to paying me, we responded to discovery requests. They were seeking lots of email. And there was, at one point, I think we produced over 20,000 pages of material. I'm not aware that anything supporting any kind of improper conduct was ever discovered, but the process of discovering that is expensive. And even if the individuals are entitled to successfully defend ultimately, and I hope and think with the law applied correctly that would have been true, again, the same money that's paid to defend that is taken out of the city's coverage for ultimately exposure the city might have, because the city doesn't get legislative immunity. Individuals can get legislative immunity. And then this other potential defense of official immunity, that's a bit nebulous, and that's one the courts have really got some problems with. And an official can have official immunity for doing something in their official discretionary authority, acting in good faith. And good faith is the hardest thing for the courts to define what is or isn't good faith. But there's a legal term, and that's a legal term. It's not what you and I might ordinarily mean as good faith. Generally, if they believe, a good test of good faith is that they generally believe what their actions were doing was lawful.
This is a 5-second follow-up.
Yes, sir.
It'll be fast. So again, the reason why I'm harping on this part is because we tend to mix all these things together. When you're talking about rules in regards to a noise ordinance that's already in effect, and how building a stadium in somebody's backyard would be a nuisance, it would seem very challenging to say that if they say we're going to uphold the noise ordinance, that noise ordinance puts them in a situation where they can be individually sued. That's hard for us to grasp that concept, and it feels like we're mixing that in with their ability to build a school. That seems flawed.
And let me try to break that into several pieces. And I'm not disagreeing with you. I'm saying these are the lawsuit accusations that I'm defending. Yeah. Okay. So I'm not saying that enforcing a noise ordinance is something that individuals who enforce it in good faith can be successfully sued for. But when you're defending a lawsuit and you raise a defense, legislative immunity is a type of defense. Official immunity is a type of defense. You have to prove that defense. So somebody sues you, I mean, the common courthouse joke is anybody with $200 can sue anybody they want for anything they want. Can they make it stick? But here, what I'm trying to talk about is, I'll try to break it in a couple of pieces. First, back to the question about the nuisance ordinance. I think that the nuisance ordinance, and frankly, there's probably even broader ordinances, that if somebody's basically being a pain in the neck to the point that it interferes with your reasonable enjoyment of your property, you can call the police, and if the police feel like there's grounds, they can issue a citation and take action. If it's bad enough, they could theoretically arrest people. So that's a tool that could be available for enforcement once the stadium is built. I don't think that the council members were actually enforcing the nuisance ordinance because there wasn't anything really in place to enforce. I'm just saying that's a tool, if it's built, that could be used. What I think the council members are being sued for is because they voted to turn down the life school plan, and the life school people are saying they legally didn't have grounds to turn it down because and I'll get to you, ma'am, in a second. When you're voting on something like this, and you're eventually going to have to potentially defend it if you get challenged in court, in this circumstance, the burden would be on the city and city officials to show that they had sufficient reason for turning down the application. And the life school, their burdens are different than the defendants would be, but the defendants would be put to having to show that they had sufficient reasons recognized under the law to turn down the application. So the nuisance ordinance is a tool to use once the school's in place, but the way the law is written, because a stadium and the school campus itself, the buildings that are necessary for the carrying out of the school's mission, are all things that the school gets to decide where they're going to put them in a city. And the city is very, very limited on what they can do as far as, number one, the first question, can you or can you not put it in the city where you want? Answer is generally they can. If we could show that there would be a health or safety issues, for example, if they wanted to try to build it in the middle of a floodplain, we could say no. If they wanted to build it and not comply with building codes for health and safety purposes, we could say you can't do it that way. But is generally the issue of can they even put it in the city, and can they put it their campus in that location? we don't have much of a right to say no. Now, if on the campus, if they're going to put something in a floodplain, we could say no. And that was one of the things that was looked at, and none of the assets, so to speak, of the school, buildings or structures, are going to be in a floodplain. They've got floodplain, they've got drainage plans. Okay, I'm sorry. Let me put it up here. Is that better? Okay, sorry. So they have plans in place to deal with drainage on the property and to keep it from flooding neighboring properties. Those are the kinds of things that can be used if the school is not going to properly address those kinds of public health and safety issues. So can they eventually succeed in a lawsuit against the individuals? I would hope not, because I think everything the individuals did was in their legislative capacity. But going through the process of litigation to prove that is expensive. And at the end of the day, if you're successful in defending the individuals, you still have to defend the city, because the city doesn't have that kind of an immunity defense. Okay. Oh, she had her hand up first.
Please correct me if I'm wrong, but it is to my understanding that the property that Life School purchased was originally zoned as residential property.
So the answer is yes. They bought it from an entity that had been formed to create or to build a charter school on that property. It had been vacant for a long time, I think about 8 years. The previous owner had bought it with the same plan or concept of a charter school.
Were they given any guarantees from the Planning and Zoning Commission that the zoning would be changed from a residential to a commercial property? Ever?
So,
Prior to their purchase?
and can I ask you for clarification?
Yes.
Okay, so is your question, will any portion of the property, the Life School property, ever become commercial? Is that it, or?
Were they given any guarantees that the current zoning that they purchased it under would change after purchase so that they could commence their project?
Jim, let me answer that question, because you're asking him a question he doesn't know. One, no. Two, it's still SF-13. What Mr. Jeffries is telling you, the school district gets to make the choice where to put the school. They can put it in a residential district, commercial district, in this case, a single-family 13 district, I think is what it is. So they were entitled to put the school where it was. The reason that they had to come through the zoning process was to get relaxation on height, building mass, the stadium, the practice fields, the setbacks. That's why they came through the zoning process. Not really maybe to tweak, because in that district, that's the 2.5 stories. We didn't change that. The setbacks were only 10 feet, and then we got them to move it more than 10 feet away from the property line. And the building mass and the articulation, so those are the kinds, and we said we couldn't address that in a SF-13 district. You would have to go through, so the base zoning of this property is still single family. If Life School decided they were going to pack all their stuff up and went home, someone could get a building permit or file a plat to subdivide it to SF-13.
And it appears to me that the board was just siding with the current regulations and voting against the Life School project.
Well, to Mr. Jeffrey's point is, we would lose our immunity if they met all the requirements, and the state law says I've got to grant you the use, and if you meet all of the regulations for that use, now I don't have a reason to turn you down, then the immunity issue becomes to the forefront. So what did you use to turn down the zoning, other than you just didn't like the school?
Thank you.
Take it further.
This is going to be really quick. For clarification, there was noted that maintenance of property value was a part of the cases. So in Austin, maintenance of property value. So I just want to know, as a homeowner in the area, is my property value protected just like the school districts?
The short answer is, I don't know what impact it might have on property values, but because the school district gets to choose where they put their school, it can impact your property value. There's no doubt of that.
I guess what I'm asking is, as they get to sue for their diminished value, if our value is diminished, do I now have the right to sue?
I hate to give you legal advice, but I think that'd be a tough case for you to make. And the school district, I'm sorry, the Life School is not claiming that they've lost value of their property. Their legal claim is they've lost a right protected by state law to use their property the way they see fit, and that it has cost them money because they could have and should have been able, according to them, built this a year or more ago. And the old saying, time is money, is part of their argument. Plus, they have increased cost of construction that they're claiming is out there in the world. One thing that just the people involved in the construction world have told us, me included, is that the cost of construction has been going up around 4% a year. Who knows what the economy is going to do next year? But cost of construction has gone up. So they're saying by delay, the city should be on the hook for any increased expenses to them. I'm not sure if that would fly or not in court, because they'd have to prove it. But that's the kind of money that they're asking for, which could be a lot of money on a project that could be $100 million project. So they're not exactly suing for loss of value of property. They're suing for legally different concepts, if that makes sense to you.
I'm speaking to the case, I believe it was the Austin ISD case, where it was maintenance of property values was part of the case. So I'm not speaking to Life School, what they're suing for. I'm saying Life School gets built and my property value goes down, and now I have diminished value. Do I get to sue Life School?
I can't advise you on that, ma'am. I just simply can't.
My understanding of the Austin case, that was raised as an issue, but they lost. Now, you have a private right because your property is different from your neighbors. You're different. So on a case-by-case, that's your individual property right to sue the school if you think it is a nuisance in its operation, and it's a nuisance per se. But the mere placement of the school is not a nuisance per se. The operation of the school may be, but that would be a private right that would be your private right as a property owner or an affected property owner.
Been very patient, ma'am.
Thank you. Good evening, everyone. I had a question about expansion, possibly, of the stadium. I know it's regulations and dimensions and so forth that has been talked about throughout the meeting, but what's the possibility of them Life School wanting to expand the stadium past what they initially quoted?
If they are going to expand the stadium, they would have to come to the city and submit plans. They would have to get approval of the plans, just not just the structural elements, but show that the, I'm going to call it the physical configuration of the property would support an expansion. If they wanted to try to build Cowboys Stadium at that location, it may not be big enough to handle the traffic and so forth. So the short answer is they, within reasonable and in compliance with health and safety standards, construction standards, they might be able to expand it. Now, whether the future holds that they would want to expand it, I don't know. The stadiums that they've pointed to that exist are, they think that the 1,000 seats is going to be adequate for their needs, at least indefinitely. Do you remember the location they pointed us to that's another private school not terribly far away?
I want to say Waxahachie, and then there was another one that was in North Dallas County, but I don't recall the name of it. One of the stadiums that I thought that were comparable was John Paul II, which is a private parochial school at the corner of Coit and Park, and it's actually in Plano, is similar size, and then Jesuits football stadium at Jesuit High School at Northwest Highway and the Tollway and Forest area. They're about the same size. Those are a little bigger than what has been proposed, but that might give the public some concept of what's being proposed. They're not encased in anything. They're just metal stands. The one near my house is Legacy Christian School, and it's a little taller than this, but it's just metal stands with a press box on it and lighting. So those are some that are comparable. You can get on Google and look. Liberty Christian, Jesuit, and John Paul.
So that's, excuse me, that's a concern I have with the expansion, because they, Life School is presenting one thing, but then throughout the years, is, their population, if they're, actually going to be able to come, will expand, So that was one of my concerns I had, and what type of, I don't know, what council would accept as a way for them to expand. Like, what would they take in consideration for, yes, they need to expand once it's presented?
I think that the at that point in time, the council would be using the same analysis that they did for the original stadium. Is the property itself, including parking, traffic lanes, on-site, off-site, will all of that support an expanded stadium? And I think, again, we'd be going through the same analysis and process generally that was done to this point. So the answer is they might be able to expand, but we'd have to see what they brought forward at that time.
Okay,
I mean,
thank you.
It would have to go through the planning and zoning. They'd have to file an application. They'd have to go to planning and zoning. They'd have to come before the council. People would have to receive notice. You would get to participate in the process. Hopefully it can't expand too much just because where it's squeezed in to where it is. But they would at least have to go through that process. And then I would assume their operation of their current stadium would have a large impact on you actually speaking about what the noise is and what the concerns are through their operation. And then it may get to the point where it is a nuisance.
So my question was that I know they purchased the land from another charter school, and what my understanding was before I moved to that location, as well as got our house built from the ground up, that charter school was not allowed to build a school on that property, the reason why it had been sitting dormant all this time. Is that true or is that false? You don't know? Can somebody answer on the days up there? Can anybody answer that question?
I have never seen an application be filed on that property for a building permit or a zoning change until Life School owned it.
Okay, so you've never seen anything, no building permit, no zoning change, but we are going to allow this zoning change for this school? Is that what we're saying? Is
No,
that
that's
what
not-
you
that's not
guys
what
have
you
agreed
asked me.
to? I'm just trying to understand.
You asked me if there was a prior charter
Yes.
school.
Ye-
And you asked me if they could not build on that
Correct.
site. I never saw anything where they filed a building permit or they requested some kind of zoning change to build something on
Okay,
there.
did you check?
No,
Why not?
I have no reason to check.
Because we are the constituents. We are you guys represent us.
I understand.
And so, no. And you have a lawyer here that is representing you all because you said, or from what I understood, that you guys are getting sued individually and the city is getting sued, correct? So if that is the case, why didn't we do our due diligence? Because you guys are elected officials, why didn't you go back and review to see if that documentation was in place and what was the outcome?
I can try to answer that.
Because you just got hired, right? Just for this particular. So did anybody else? Because you just got hired. That's what you said when you came up here to represent the people on the podium. So my question to the elected officials that we've elected, did we go and check to see if anything was submitted and was it rejected from the other prior school district? Because what I'm not understanding is, because I'm an educator, 25 years, why would a school district build or purchase some land and then let it sit dormant when they expanded multiple areas of their old school? So for them to get this vast, beautiful property and not build on it, but expand in other areas, why was that? Why didn't they build on it? And then two, did you guys go back and review those documentations and see if it was rejected? And if it was rejected, why was it rejected?
Okay, excuse me, the interim city manager is going to respond. I can't respond.
Okay, well, who
You won't
can?
get any response- Excuse me. You
Yes.
won't get any response from the council members up here that are currently under suit, because that isn't going to be resolved for some time. So we can't respond. So the interim city manager's got an answer for you.
Well, from what I understand, excuse me, can everybody hear me okay? So from what I understand is, yes, there was a prior owner that was wanting to build a school. They submitted plans to the city, but never really followed back up or took any further action. So nothing really ever came of it from my understanding. Again, it was before my time, but my understanding was plans were submitted, but no further action was taken, and they didn't follow up.
Okay, so that's what your understanding was. You don't really know, so you're just speaking in general. And my question is, will you, the board, the people who are not being sued, the other people who can, go back and see if that was followed through, or if the plans were submitted and then it was rejected? Because I'm still trying to understand. I thought, again, like this neighbor of mine asked about the single family, and I thought that's what we were voting on, to see if they could change from single family to whatever it is, whatever the law is for building a school district, a school. And two, with the plans that Life School have been submitting, they've submitted several plans. When on the last vote that we had, they said they were only going to build a high school and a middle school. However, they had an elementary school that they said it would be an expansion piece to that. There was going to be a stadium and all of these things. And my gate that we exit out of every morning, because I'm a school teacher, I'm an educator, I have to get out of the gate what parameters is the city going to do to ensure that I can get out of my residential area in time so that I can support my students in my community, the community that I purchase land in and I serve? So what is the city going to do for us? Because we've already seen there's been 4 accidents since the last meeting. I think that was 6 months ago or whatever. And we could not get out of our gate, and no one would allow us to get in and out of our gates.
I think the question was about the traffic plan or what traffic mitigation they're going to, if I understand her question, I think she was asking what the mitigation was for the increased traffic, if I'm not mistaken.
I had 3 questions. The first one was, are we going to check to see if the plans were rejected, and if they were rejected, why were they rejected? And if they were rejected back then, why can't we hold on to that same rejection? The second thing was, what is the city going to do in order to ensure?
Let's take them one at a time, okay?
I gave you one.
All right, I want to answer. I'm going to answer one.
But you said you wasn't here, so I'm asking
Well, I
you guys
was
to
here.
review that.
All right, I heard what the manager said, and from that I can glean this, that I as a property owner filed an application, and if I never did anything with it, I'm never going to see it because it's never going to get to P&Z. It's been withdrawn by the applicant. There's no reason for me to do anything else. That's why nothing was done.
Understood. I understand your answer, and I thank you for that answer. However, he said that he didn't know. He's just generalizing that was the case because he definitely mentioned that was before him. And I asked specifically, did anyone check? And he said no. But what I think is what he said, and it's on record because we're recording this. So my question is, can you guys go back to review that and see why was it rejected? And if it was rejected, then we need to hold to that same standard.
I understand.
Ma'am, I'm gonna go out on the limb. I'm gonna answer the question. I was there. I was in possession of those plans. They were submitted with no application, and they never returned. Not a phone call, not an email. They never returned to follow through with the project. So it was not rejected. It was their choice not to go through with the project.
Okay, and secondly, how can they change, and you may have said this already, how can they change from single family to whatever the law is to build a school? What is that law and how is that applicable? How can they do that? Because one of the things that I mentioned is that when I purchased my property, I had to follow the rules of the HOA. I couldn't, because I bought the property, I couldn't change some of the HOA rules that I didn't like. And those people who purchased the property, the reason why they came to us originally is because they wanted to change the zoning from single family to whatever the change was going to be.
All right.
To commercial.
All right.
So my question was how?
Okay.
Because that's what their original plan when they came to you guys was to change the single family to commercial when we were over there in that other building in the Civic Center. That was the first meeting.
Okay, I'm going to explain that to you.
Try that, Bob?
Yeah, I will. All right. What the law has told us, that the school, in this case, the life school, you need to move so I can see her, she can see me. It's court case, Texas Supreme Court. Texas Supreme Court, it is the city of Sunset Valley versus the Austin Independent School District. It was decided in 1966 by the Texas Supreme Court. And the Supreme Court told us in that case that a school district is a political subdivision of the state of Texas. And as a political subdivision of the state of Texas, the decision on where a school is located, even in a residential district, is the province of the school district. And even the city zoning authority is subservient to the school district's authority to decide where their schools are going to be, because that is the legislative plan for the state of Texas as guaranteed by the Texas Constitution. And the school has that choice, okay, not the city. So they can put that school in a residential district, they can put that school in a commercial district, they can put it in an industrial district, they can put it in a retail district.
So why were we voting on that if that's the case? Why did we have to vote on the change of the zone?
Let me explain to you. If I put that school in that zoning district, I have to abide by the zoning district's regulations when I build that school. There's a difference between the use and the regulations for the development. So if I make a choice to put my school in a residential zoning district, the height requirements, the setback requirements, the landscaping requirements, the screening requirements all apply to the school district because those are health, safety, and welfare regulations.
So
which
basically what you're saying, planning and zoning and the city council has no credence. That's what you're saying.
you're
You have
interrupting.
no power.
You're interrupting me.
Yeah, I did. I'm through.
All right. So.
You have no credence.
All right, so they get to decide where to put it. I get to decide what the regulations are when they build it.
So I'm sorry, and I don't mean to cut you off. I just want to, because you
excuse
made
me.
that point.
Ma'am, excuse me. Sir, I'm going to have to ask you, we're trying to conduct a respect.
I made my point.
Okay, but this is the second time.
Planning, zoning, and city
Okay.
council has no
Okay,
credence.
this is the second time.
It's a moot point.
Okay, if you're done speaking, okay. All right, thank you. Okay, go ahead, ma'am.
Yeah, so what I'm saying, what I'm asking is that the single family zone has no standing, no legal right over any school that purchased single family land and they can build a school. That's what you're saying.
Yes.
Okay, and then my follow-up question is, why were we voting on the change for the zoning? That's my question, because if you guys knew that originally, why did we have to come and write all of these letters and say these things?
Okay,
You guys knew that, but you never told us. So why is that now? Why is that the stance now?
What we told you was, as I recall that night, and you can go back and watch the tape, we didn't have a right to decide where the school was going to go. We could decide how high it was going to be, how many light stanchions they were, if it created a problem here, the screening.
Right.
That's why they went through the process. That's the things that we were attempting to narrow it down to vote on.
Understood.
And that
Understood.
and traffic.
But we had to have a follow-up meeting because the community members never knew about their plan, their process, or anything. The original letter that was sent out to us was that we were voting on, or the Light School was trying to get a zoning change. That was the first meeting that we had over in the community center over there. And then, because it was not handled properly, we had to have another meeting. And then in the first meeting, they had all of these plans and no one knew about it in the community. And so when I got my original letter, it said on the letter, the change of zone for Life Charter School. So why was that documentation sent out from the city when you all knew what the Texas Supreme Court versus Austin 1966? Why did we waste our time on that when you guys already had your hands tied on what could be done on the property? I'm still caught up on why do we have to vote or voice our opinion about the change of zone when you, as you stated, the Texas Supreme Court versus Austin 1966 case was already in play.
Because they wanted some relaxation of the SF-13 zoning regulations.
So we're giving them relaxation, we're granting them relaxation, and the taxpayers
Wait a minute.
are having to just accept because you guys are allowing them to relax.
I'm getting frustrated because you're not letting
Why
me
you're
finish.
getting frustrated with me, sir? I'm being calm. I'm asking questions. You're saying something. I'm responding to you. As a council member, how would you tell me that? Why would you even say that? That's so unprofessional.
Well, first of all,
That's
I'm not-
number one. That's unprofessional,
all,
sir.
Mayor, I'm going to call
And
point of order.
I did not raise my voice.
Mayor, I'm going to call point of order.
All
right.
Look,
Thank-
first of all, I'm not a council member. I'm a city attorney.
Okay, same difference. We still vote.
I understand. I'm trying to explain to you.
Yeah, but you said you're getting frustrated as a government official. You should not talk to anybody like that.
there's
And
been
if
a-
that's
there's
the
been a
case,
point
you
of
need to
order,
go back
ma'am.
and get some professional guidance on
Ma'am.
how to talk to your constituents who put you at that seat.
Ma'am, there's a point of order that's been called out, and in large part, it's because it's been a lot of repetition.
I understand that, but he doesn't have the right to tell me when I'm asking him direct questions on something that he said. I'm trying to get clarification, and he's frustrated. From my standpoint, he doesn't know what he's talking about. You said you wasn't here when the first original plan came about. So what I want is facts.
No, ma'am.
What I want is facts,
Ma'am,
and you guys are just
I did not-
regurgitating things that are being said and what
Okay.
life is suing the city. And for me, it's like you're disregarding what we said because we have spent our money to buy a home in an area that was zoned for single families, and now because a school district is threatening to sue, you guys are
Suing. They're
tucking
not-
your
they're not-
tails and
ma'am, they're
running
not
and
threatening.
not representing
Ma'am.
your community members.
I'm sorry, but you haven't been listening. They're not threatening to sue. They have been suing us.
Okay.
And there's a court hearing tomorrow that
Sir,
will resolve
and
the
that's
issue.
why the city has legal counsel. The council need to do his job
We're doing our job. I'm gonna have to call on
because
somebody else.
because you're getting
Mayor,
I'm
I want
irritating
to
you
call
now,
another
right?
point of order.
Because I'm
Yeah, we
irritating
can-
you
I
now.
want to call another
This is
point of
so
order because
unprofessional.
she's out of line and,
Okay.
and her stuff, and she's repeating herself and,
Yeah.
and stuff. She's interrupting when we're asking, so we need her to stop.
Yes, we need to keep decorum in here and respect and speak in a respectful tone. So at this point, we're gonna move on to the next question. Right here, lady in the green right here. Or was there somebody ahead? I'm sorry. Before she goes, we have this gentleman standing right here.
No, I was next.
Okay.
Yes.
All right. Patiently waiting.
Yes, thank you so much. I will say that this is quite disturbing to me as a citizen, a voter of this city. And I know we're going to have an open mic to talk later, but I just wanted to say this about the whole thing about the noise. And I know we've talked about it, we've shared our feelings on that, but it seems like no one is speaking on behalf of our community. Those concessions that they talked about, that Life talked about making for us, building trees, baby trees that's gonna buffer the sound. I'll be dead in 20 years by the time those trees grow to buffer the noise. The noise and the traffic are the two huge things that we have shared that's really concerning for us. And I will say that I would like to see the city council and the city of Duncanville stand up for our community. We did it the right way. We came before you, we rallied the troops, we rallied our neighborhood, we did the research. And this is what, when we say, we tell people to vote so we can have a voice. We want to know that our city council stands with us. Because when we had the last vote, the supermajority, 7 out of 8 said, let's not move forward. And it's very disheartening to see that we're going to, appears to me, and I know it's not decided, that we're going to lose everything that we fought for. We didn't want the stadium. We didn't want the school. We didn't want all the traffic. We didn't want all the noise. And it appears that we're going to have all of that. It appears nobody is standing up for our community. It appears that nobody that has the authority can fight for what we are fighting for. I I feel like where we are now is doing the right thing. It's not the right thing. This community says this is going to affect our quality of life. Who cares about our quality of life? We can't get about neighborhood. We're going to be on Friday nights. We can't enjoy our families on the patio because we're going to be competing with a stadium. There has to be some type of medium. There has to be some type of concession. Somebody has to say, what can we do for that community so that they won't be totally at loss? Because it appears that with everything you're saying, there's no concession for us. And I know you're going to go back into executive session and you're going to make that decision. And I'm disheartened because it seems like nobody is speaking up for us.
So, Mr. Hagan, I got a number of questions. I was wondering if you can answer them just, serially. So my understanding in listening to you, and by the way, I'm an attorney, so I understand where you're coming from in terms of your analysis of the statute. So what I'm hearing from you, Mr. Hagan and Mr. Jeffries, is that if a school district buys a piece of land, then therefore they can designate that land as a school. Is that correct?
Yes.
Yes.
Okay, and so then if tomorrow I set up an LLC or a 501c3 and say Corey Johnson's school district, and I go buy a piece of land, I can buy my own house. I can then just designate that as a school?
No. You have to have a charter from the state of Texas.
Okay, so as long as you secure a charter and buy a piece of property within the state of Texas, and you have a charter, then by definition, at least under this Supreme Court case, you can designate that as a school.
They would have to qualify it to be a charter school, and once it's deemed a charter school, and that board of directors is appointed, those board of directors could decide that the property that they own that gets designated as a school. That's what the law appears to be.
Okay, and that goes under the holding of the Supreme Court case, the Sunset case.
Well, if you take the statute, it says for the purposes of land use regulations, then what applies to a school district applies to the charter school, the theory being that that's the state of Texas. Constitutionally, they are charged with public education. And by legislation, they've created school districts, and now they've created charter schools. And they said the charter school enjoys the same status as the school district. And then you take over that, you lay over the Austin Independent School District case. Now, I understand that the difference was, and they said, well, it's political subdivision of the state. It's an independent school district. It has local trustees, local election. They tax locally to provide for the school. But that's also by legislative fiat, right? There's legislation that allows to create independent school districts. So now we have charter school districts. That's why it's a difficult argument to make.
So basically when A.W. Brown bought that property, they could have, even though they didn't ask for an immediate change of zoning, they could have, because they were a chartered school, they could have just by, following the requisite process, just declared that area a school because they own that parcel of land, right?
Yes.
Okay, and so my understanding is that, and that's what you were getting at, is this is the statute or under the Texas Constitution, whatever. Essentially, every charter school, once they buy a piece of property, they don't have to declare to the neighbors that they're going to build a school there. But once they buy that property, they have the inherent right to then change that property to a school, essentially. I can't hear you.
I didn't have that. They would have to plat the property if it's unplatted. So the Brown property was unplatted. So they would have to file a plat to plat the property. They could decide to put a school on it and leave the zoning exactly as it is, but they could not deviate from whatever the base zoning was on the property in terms of size of building, setbacks, those kind of things.
I see. So then, when we were here before, as this young lady was pointing out, we weren't voting on changing of zoning. Was there ever a vote
There was
to change the zoning?
Let me explain to
It
you.
was my understanding of what you said, just so I can summarize, is that we were voting on a plan, a development plan, or they were seeking a SUP, and we were voting. They were voting on that.
That's a misunderstanding.
Okay.
Planned development means it's a zoning category under our zoning ordinance. And so if you want to do anything, so SF13 zoning has lot size requirements, it has building size requirements, it has landscaping requirements, it has setbacks, all those things. Well, to build a school, they would have to build some property or a building that's larger, right? And it comes with all kinds of other amenities, if you will, with the school district, because they get to decide. They can put a soccer field there, they can put a bus barn there, they can put an athletic facility, gymnasium, but they can only build it to a certain height. They can only build it to a certain mass. So for them to build a high school, they would have to get a planned development to meet the requirements that they needed, so they would have to ask for those changes. And in order to get those changes, they would have to have a change of zoning. And they chose that zoning product as a planned development, SF13, to seek a different setback, a different building height, to allow, we only allow one accessory building, right, in a single-family residential district, so they needed that regulation relaxed or changed for their benefit to build their school.
And so the council had no authority to just say no to the mass of that building?
Yes, we did. We had, what I told them was you cannot decide on the use. That's been taken away from us. You can decide on the building mass, you can decide on the traffic, you can decide on the landscaping, you can decide on the height of the building. But you can't tell them they can't build a school there. Now, when they get to build a school, they get to bring all their toys with them. The athletic facility, the concession stand, the stadium, the bus barn, whatever it is that they can justify is integral part of their educational mission.
So is it your understanding that the city still has the right to control or regulate the mass of that school, of each building?
Yes.
So if the city decided to say they only were allowed to have a 10,000 square foot building, could the council impose that?
Unless they said, well, for a high school, I need 20,000 square feet, and that's an integral part. If they could make the argument.
So the city
And
doesn't
it's
control
not any
the mass.
higher than 35 and a half feet, which this one's not. I don't know that I can tell them I can limit the square footage.
So that still may be a potential option.
Not now, no, probably.
Okay. Well, then let
I
me.
can go back and re-justify why I turned it down when we turned it down because of traffic and because of the height factor of the building.
Well, then let me ask this much. My understanding is you guys have negotiated a settlement already, or the terms like essentially laid out? Have you guys negotiated a settlement?
I definitely think that
the outline
the
of a settlement?
things, they've met all of our requirements as to height. They've met all requirements to setback. They've met all the requirements to landscaping. They've met all the requirements of screening for that site. So if they have met and they have mitigated the traffic based on a traffic study that we commissioned, and I cannot show that their traffic mitigation plan and traffic implementation plan is not adequate for their land.
Okay, so as part of this these negotiations are ongoing, right? I mean, you guys haven't signed a settlement agreement.
We haven't
right?
signed anything.
So as part of this settlement agreement, why wouldn't you guys at least impose some future restrictions, such as expansion of the stadium, such as if their right essentially comes from the fact that they are a school under the regulated statutes. That doesn't mean that then they should be able to build a stadium and then invite third parties to play at the stadium on different days and different seasons. Can we at least get that as part of the negotiation of this settlement, since the city's going to take the position that their hands are tied? Because see, to me, that seems like a legitimate request. If you're going to look at what we as the residents want, is to limit the impact. If you guys say you don't have the power to stop them, if you guys say that you're concerned about your personal liability, which I would be concerned about too, I'm just concerned that we have a city that doesn't buy enough insurance for our council people to not have enough of that. But
That's not the case. Don't
well
say
then,
that. It's
let me,
the kind of lawsuit that's
okay,
you can't
so
get coverage for.
Can I make a suggestion?
Yes.
As part of the settlement, can we get some additional future restrictions on the growth of this facility and to its uses by third parties? Fine, if the law says under Texas, I'm a school, I can declare any property I own a school, and I can use it as a school, and I'm only subject to the same rules and zoning as the other entities in that facility, in that municipality. We can, and I think we have enough leverage based on what Mr. Jeffries is saying, to at least ask for future restrictions, because it seems to me that the likelihood of them actually getting damages is limited. The likelihood of them actually collecting attorney's fees is limited under these circumstances, in my experience. I mean, it's a legitimate threat, but it's unlikely to happen, right?
I think it's a legitimate threat, and I think it's potentially likely to happen because.
But not 100% of the
Not
attorney's
100%,
fees.
but
You never collect 100% of attorney's fees, and under these circumstances, you could appeal it all the way to the Texas Supreme Court. Those fees.
let me get a sip of water. Sorry.
It's not a real legitimate threat.
So
in terms of its impact, in terms of the decision making of how much we can fight with these guys.
So let me talk starting there and maybe going backwards. How much can we fight with these guys? And what can we legitimately expect to put into a negotiated outcome? Because both the school Life School and the Attorney General are taking the position that they are not going to agree to any restriction that would be imposed on this school different than what would be imposed on any public school. Some of the things that I think you're suggesting or potentially asking for are things we don't really have the authority to regulate. And so as an example, if we're going to say, well, you can't rent it out or lend out the stadium to some other school or group for days when you're not using it as a stadium, we could only justify that if we could also show we would impose the same kind of restriction on a public school. And, I'm going to give an example. Public schools often, as a way of getting money, will rent out their facilities for different purposes. And if they've got the facility in place and it's considered integral to their mission, then I think they get to use it in a manner that's consistent with their mission, which is, of course, you got to have funds to operate.
That's the city's burden? That's the city's burden to prove that fact?
I think so, yes.
I don't, fine, I'll take you at your word on that. But what I heard from you was that it was the school's burden to show their use. This is essential use. And so it seems to me, or you can legitimately argue, that it should be the school's burden, or in this case, Life, their burden to show it's an essential use for them to also rent this out to third party? Because then to me, if Life School is now able to just declare, hey, we have a right as our status as a school to build a school here, fine. We don't have to then adhere to the size, no matter what the city says, because all we do is wave the flag of this is essential. We're a school and this is essential. Oh, we need a stadium, so this is essential. Oh, now you're also telling me that, oh, it's also essential that we can also invite in third parties. So now every weekend they can have soccer games, they can have lacrosse games, they can have whatever games they want year round at this stadium, third parties. And you're telling me that's also essential?
I'm saying I don't have a definitive answer, but I do know that if all of the parts of the Life School plan that have been presented have in one fashion or another been recognized as essential or integral to a public school. The building, the parking, the stadium, those have all been recognized as integral to the school's mission. So if they're going to be in place and allowed to operate and have those facilities, then if the city, once they're in place, is going to try to impose restrictions or regulation on them, we would have the burden of showing that what we're doing is not treating them differently than what we would treat as a public school. And so the kinds of restrictions that you're talking about, if we're not going to impose the same thing on a public school, we would not be able to impose on Life School, because they're recognized as part of the state's public education system.
Well,
and
I hear what you're saying.
yes,
You're in the middle of negotiating a settlement agreement. Nobody's lost anything yet. You can get these restrictions and let them agree to those restrictions. What is preventing you from even asking for these restrictions? There's nothing preventing you as part of a settlement agreement for asking for these additional restrictions, which they can argue about, but they can just sign a contract. Please help us. You've essentially, I think you, as you pointed out earlier, you guys are on our side. However, you guys cannot just lay down and let them, what you just told them, we've given up the whole game just because they played a little bit of hardball. And I get that Ken Paxton wants to support these entities that are not subject to any Democratic control. These charter schools support the Republican parties because they allow them to do what they want to do and sit here and bring in entities owned by private people who don't live in our neighborhood and can build it here, don't care about our neighborhood, wouldn't live in our neighborhood. But my simple point is, you guys don't have to lay down. At the very least, you could ask for some restrictions, period. And I'm telling you now, I've been a litigator for 20 years. I'm happy to work on this case pro bono. I worked on this. If you guys are worried about more money or more resources, I'm happy to help. But for us to just lay down, I just disagree with that. One last question, just who's actually making this decision in terms of at the trial level? Is it an arbitrator? Is it a judge? Do you get to go to a jury?
so the short answer is, if the statute is followed, it's decided by an arbitrator. It's not decided by a judge or a jury.
Has the arbitrator been, I'm assuming the arbitrator has already been chosen?
No, has not been chosen.
Is it an arbitration panel?
No, an arbitrator. The statute is, back to one of the challenges that got the Attorney General's attention was the statute is fairly vague about who the arbitrator would be and how the process exactly would work.
Is it binding arbitration?
It
By that I mean, so if the arbitrator decides there's no appeal? Is there an appeal?
The short answer is yes, there would be an appeal, but the arbitrator is the one who makes the decision.
Is is the arbitration judged on the normal standard of arbitration, unless there's like some sort of malfeasance fraud, then whatever the arbitrator says goes? Is it the same standard?
Yes.
So now I'm really confused. We haven't even gotten to the point where we fought to maybe get an arbitrator who might lean in our favor. We haven't even chosen an arbitrator yet.
No, we
don't
haven't
get to
chosen
choose.
Not choose, but said, hey, all right, let's arbitrate.
No, because we'll have to get some court rulings to get to the point to rule the statute unconstitutional. And what we're doing is we've spent all this time doing initial discovery, and we've eaten up a lot of our coverage through that process.
Well, we're in favor. Are we in favor of arbitration or not?
We're the ones that raised it. We're the ones that have used that threat to get them to at least talk to us, because they would not talk to us. They were going to the mat.
So,
Here's
is there an outstanding ruling on whether or not you can compel arbitration? Is that now a motion before the
No.
court?
No.
Then whose court is this in front of now?
It's in the 134th.
What's the judge?
Tillery.
Tillery. Judge Tillery. Well, haven't at this point we waived the right to arbitration?
No, it's been raised as an issue. It's not a trial tomorrow, okay? It's not trial setting.
And
It has to be raised, and someone has to make a motion, at least to get a, what I say, interim ruling as to what's gone on. And we're locked into a heavy production pretrial process. And we're eating up all of our coverage with pretrial matters for discovery. At some point in time, this case would be tried. It may be 2-3 years. And I know that you would be happy to know that in 2 or 3 years, that property has not been developed. But when we do that, we're staring down the barrel of now they don't get to build their school. And the cost today versus the cost 3 or 4 years from now may be 4 or 5 times more.
Well,
those are their damages.
I hear what you're saying. Their likelihood of collecting those damages are also fairly low, in my respectfully, in my opinion, in assessing a case like this. I also would have, if you have the right to arbitration, then you could have just filed a motion to arbitrate, and we'd be in arbitration, and you'd have a lot more leverage if we can get the right arbitrator. Just respectfully. But at a minimum, you guys are in the middle of negotiating a settlement. They haven't won anything yet. Tillery is an elected judge. They're easy to get rid of, the judges in Texas, and he knows that. Enough of us show up and say, hey, we're in Duncanville, just wanted you to know that. Tillery might strongly consider the position of the city of Duncanville. But at a minimum, you could find an arbitrator, if it's one arbitrator, that could give you guys more leverage to negotiate a better deal with life. If you're right about everything else. If you're right about, hey, if I'm a charter school, I can declare the use of any land I own to be a school. And that's all I need to know. Once again, I'm free to help you guys if you're trying to defray some cost.
Thank you.
One of the themes that he brought up, and I just want to also piggyback him. It's my belief, I'm only speaking for myself here, that I believe that there's a lot of people here who have had our back. And I just want to say that I do believe people have voted the right way, that have done the right thing, that have made the right votes each time. Which brings us back to, I think one of the themes you're hearing from this community is what we don't want to see now is a laydown. We do not want to see a laydown. Yes, we know that there are rules and laws that are in play, but we keep asking these two questions that I don't think we're convinced about, which is, how does somebody individually get sued for following the rules? Because we don't understand that yet. And then in addition to that, what we're looking for now is, hey, there are ordinances, and we do want a fight on this. We do want to make sure that, no, you're not going to, you can't, this issue about the public schools and the same rules, the public schools does not come in, if they were an elected board, and build a 17,000 seat stadium and go, well, it's 1,000 a day, now it's 17, but you can't restrict me from going to 1 to 17. No, there should be restrictions that are allowed, that are put in order for you to agree. And if they don't want to do that, then yes, there should be an arbitration. There should be something. What we just don't want at this stage is for the moment that they play hardball, the city lays down. We need to have people that are fighting for us, because keep in mind, once you go in and say, okay, yes, where is their restriction? There's no more restriction because the city gave it to it. To the point about the value of our properties, where is our way to go as the constituents to be able to protect ourselves if the city just go ahead and endorse it? You guys are our protection. You are our protection. That's as simple as it is. Regardless of what the state does and makes a rule of, you guys are our protection. That's just as simple as it is. That's why you were elected. So it is our hope. We're not coming to you speaking negatively. I personally am speaking positively. I celebrate you for doing the right thing up until now, and I'm looking forward to us finding out that you're going to do the right thing going forward. That's what we're looking for, and that's what we're hoping for.
I would like to ask the attorneys, before you go back in executive session, is your recommendation already going to be, has your mind already been made up? You've heard all of our comments, you heard all of the statements, but based upon what was said, is it too late? Have you already committed to what you're going to do? Because if I understand it correctly, what I just heard is that you have to make a decision tonight whether you move forward, because tomorrow is too late. So therefore, that means that you're under the gun to go back into executive session after all you heard and decide one of two ways. Do I refuse to go with what they're asking, or do I go ahead and say yes? So I'm asking the attorneys, your recommendation right now is, and I know that's your legal opinion, for the council to move forward with signing the agreement and paying the $80,000 and pushing it on down the line. Is that what I'm hearing?
I mean, I'll answer first. I've never voted. I never have voted.
Your recommendation is very strongly influenced.
I understand. I explain to my clients always what the consequences of their decision are and what, in my best view and judgment, will happen as if you choose and which way you choose. I never make a decision. They make the decision. And I don't mean to put that off for them. If there's things that you want, what it is that you want? You don't want the stadium to be leased out. You don't want it ever expanded. What else do you not want? That's not going to happen, ladies and gentlemen. That's why we called this meeting, because we want to tell you what's going to happen. That school will be built at some point in time. What kind of restrictions? How are we going to measure it?
The same way you made your point when they got complaints about noise. The same way your officer supposedly have some gadget that tells the noise level. We know that. Mudhook is an example. So we know you have a meter. And so that's the
What
same way.
decibel
Let me
level?
just tell you again, Bob, this is in my backyard.
I understand, Mark, I understand.
And
but
so
what-
I just ask you, I know what you just said, and I respect what you just said. Sitting back with the executive session myself, I understand that you give us your recommendation.
I give
Based
you
upon
advice.
you giving us giving them a recommendation, in most cases, your recommendation are accepted by most of the council members. But we're asking you, based upon what Attorney Johnson just said, is to really, I'm thinking it's maybe too late. I'm thinking you're already ready to sign on the dotted line. And that's what I'm afraid of, because had it not been that, you would have called this meeting months ago. You'd have said, you know, we got sued, and we want to make sure that before we go in and start talking to Life School, community, what's your thoughts? But right now, you're on the borderline, and the borderline is I either sign tonight and authorize the council to sign tonight, or tomorrow I'm sued. So
No,
all
you're-
this information
we're
we just
already
giving you is good.
sued.
You're sued. Well, the answer is to settled. You ready to sign on the dotted line to settle?
All right, so what else is it you want? Tell me now. All right, I got it noise meter level.
We said that the stadium is not conjunction right back up to our properties.
It is where it is. I don't think it's ever going to change. We've asked that. I've asked on several occasions to move the stadium. It can't be moved other than where it's located right now.
I'm saying those 6-foot trees that they're going to put, thinking it's going to block the noise. Invest in some different trees that's more maturity trees. If you say that's going to block the noise, that's my comments.
With this school being built and our resources being sent to EMS, fire, and police, how is the city going to make its money back from this school being in the city of Duncanville?
We're not.
Yeah,
It's going to cost all the taxpayers.
Say again?
It'll cost all the taxpayers. If they don't pay taxes.
Right.
I understand. We understand that. Look, I don't think there's anybody up here that's happy about this, including me. This is a hell of a way to end a career, to have to sit and tell you what in the hell the law is, but it is the law. So if you want help and you want me to ask for things, you got to tell me what you want. And I'll ask. I don't know if we'll get it, but I'll ask.
I believe one of the things I would love to see is if we talked about pro bono attorney helping there, that what I would love to see is, because I don't like the walking up on the day before, is for ability for us for the neighborhood to provide a list of our expectations, because by its least, I'm expecting for the zoning as it exists to be, when the noise was, I get the part about the school. I'm not arguing about that. But all the issues of the noise ordinance and the restrictions of changing, of expanding to third parties, all of that stuff should be in place and should be a part of what is negotiated. And to be fair, just though it's said out loud, you're right. They probably aren't going to like that, right? But the delay, the gentleman from Life Schools was specifically asked, why don't y'all build this in North Dallas neighborhoods? And they specifically said because it's not worth it to them, because they don't think there's a need there, a want there, and they know that they didn't say this part, but it was implied and we understood it. They know that the pushback would keep going and going and going and going till it's not worth it. And what we're saying is it better be make it worth it to them. Make them have to decide this is worth it. Because at the end of the day, laying down and giving them everything they want, that's an easy battle. But when he made the point about how big the building could be, right? If our rules are it's this amount, it has to be this and restricted to never expand. You have to make it so that they have to really think, A, is this worth it? And if they do, listen, we know y'all fought, but don't lay down. Don't lay down.
All right, I will share with you that we asked about the noise. They said that they would follow the UIL rules. That was their response.
But UIL rules are for people who are building stadiums in front of streets, not in neighborhoods.
Well,
and yes, I know that there are stadiums in neighborhoods, but they bought their property with that understanding. We bought our property under the rules that exist. So for them to come in, now that don't play. That doesn't work. On the stadium, not the school itself. The school, I get that issue.
The stadium comes with a school. That's the difficult part about this.
Okay.
I know there's other schools that don't have stadiums, but they're going to tell the judge, and they'll get someone to come and testify that the stadium comes with a school. We already have asked that. We've had that fight with them for 8 or 9 months.
Right, and if they do and they keep going back and they have to say, well, now we have to, because now it is the burden of proof that this is essential. All we're saying is, yeah, they need to make that fight. They need to determine that it's worth it. And again, my problem is from the money side of things is when we're saying, oh yeah, they're going to have to do all of that, but we shouldn't do it because Miss Gooden might get individually sued. I'm not convinced of that argument. That's the part that I'm making. I do agree that they might win. What I don't agree with is that these people who have fought for us this whole time now have to stop fighting for us because they might individually get sued for following the law. That's a challenge, Bob. An honest challenge.
So they did get sued. So they fought that fight for you. But how much pain did they get to?
That's what we don't want. That's what we're trying to. What did they do wrong?
Okay, I'm not saying that the lawsuit, that we didn't have our moments and then we haven't not tried to. I mean, if we were going to cave, we would have just voted for it in the first place. And then this would be over and the school would be built. Maybe none of us would be up here, but that school would be there. And for our trouble, here we are. And I'll be honest with you, I told a number of you when we were together in that briefing room back there exactly what I've told you tonight. I did. I swear to God I did. I'll go to my grave telling everybody what the consequences of what we did on July 15th, 2025, and that this day would come. And it's now here. And what I said is they get to decide where the school is. They get to decide where a school is located. They get to decide what's integral, because that's what the legislature has done. Did it to you, it's done it to Waxahachie, it's done it to Red Oak. They have schools in other places.
Are you not speaking at all? Is she not speaking
They have a stadium in Waxahachie.
Okay. Are you not speaking at all? Okay.
But they get to make the decision, not the city of Duncanville. That's the problem that's the difficulty. Yes, I know you've got some retort.
Yeah, so what is this hearing tomorrow? Is there a hearing tomorrow?
Yes.
What's the hearing
Hearing
on?
is to possibly indicate that we've reached a resolution on this case.
And what is your position as we, given the...
That's why I'm asking you.
Yeah, I think you should go...
Yet. They wanted the hearing, Life School, they set the hearing. We agreed to try to work towards a settlement, and we decided that we needed to tell you before it transpired what was going on.
And so you're going to go
That's why
in...
we're having this meeting.
So you're going to go in there tomorrow. What time's the hearing?
1 o'clock.
And so I think a number of us will be there at 1 o'clock. And I'm assuming that you're going to tell them that, no, we haven't reached a resolution because there's some terms that need to be discussed.
Maybe or maybe not, unless you tell me what they are.
Okay, then let's sit here and talk about the terms. I think there should be restrictions on the building, the size of the building.
And what are they?
All right, they should be restricted to 20,000 square feet.
How big is the building, Jim?
I don't know. I'm not sure.
What if they disagree?
Then it sounds like we don't have a settlement, and we tell the judge we got to move on, and that perhaps the city will now go seek an arbitration, a binding arbitration, and that everything else should be stayed, including this expensive discovery, until an arbitrator is.
You got to do discovery to go to arbitration.
No, you do not. You could have filed a motion to arbitrate.
I
and
know,
compel
but in this
arbitration,
kind
and
of-
that would have stayed
you're
everything.
getting that the arbitrator's going to make fact decision choices. We better have done the discovery. I'll disagree with you there. We're going to go to trial, which is all this is. The trial's in front of an arbitrator. It's not someone just to decide you're right and you're wrong based on nothing. You better have discovery done.
Yeah, but you could have had discovery done within arbitration, the context of arbitration, not within. In front
There's
of the
nothing
city.
in the statute to say what the rules are. So what we've already produced 3,500.
Well, see, that would have been even better. I would have compelled arbitration and then told them that we don't have to do any discovery because there's nothing under the arbitration statute requiring discovery. You could have saved a lot of money. I've done this a long time.
This is different.
Okay,
Trust me.
fine. It's different.
This is not a business arbitration case.
It's very similar. You're dealing with a private entity. You're dealing with a private
The
entity.
statute doesn't set any rules for arbitration. It doesn't reference the arbitration statutes. It is a unique to this procedure statute. It basically states the judge appoints an arbitrator. The two sides present a plan, competing plans, and then thank you. The judge appoints the arbitrator under this statute. There's not rules of arbitration. It's not governed by the general arbitration statutes. The parties present competing plans, then the arbitrator selects which plan he's going to use, or
So it's a binary choice.
or defines a plan. I guess you could pick and choose. So the attempt that we've made is taking the concerns that have been previously raised at, I guess, the meetings that have occurred in the past, taking into account the concerns that were raised by staff and outside expert consultants, and getting those concerns addressed. And the idea is, with those concerns that have been raised, those concerns that have been addressed, that these plans have been reviewed by experts that are paid to do so, and that do it both in-house, and we've used outside consultants, and we've got a set of plans that if it's resolved by settlement, it's resolved by the city having a voice in what's selected, and as opposed to having an theoretically independent third party making a decision for us. So the concerns that were previously raised about traffic have been addressed. The city's actually done 2 traffic reviews. One in the original process was a peer review of traffic, not an independent study. An expert was hired, an engineer was hired by the city.
I understand what you're
Okay.
getting at.
So, and then
I understand. I have a couple questions. Mr. Hagar just told the people here that we need to tell him right now what our demands are as part of a settlement. I'd like to get to make sure that when you go before the life tomorrow, you let them know that the people who invested their hard-earned money in that neighborhood aren't going to sit here and lay down easily. And so the demands, if you want to know the demands, let's give you a list right now of everything we think is reasonable.
Okay.
So the size of the building should be limited.
But you got to tell me what. I just can't leave it open.
Well, what are they currently asking for, and cut it to 50%?
Well, and let
Cut
me,
it to 70%, 90%.
in this process, because we have to have a specific plan,
Okay.
the plans have
Okay.
already been reviewed to make sure that the site would support.
All
the
right,
size
so
of
have we
the
created
building.
a competing plan? I don't mean to cut you off.
Okay.
Have we already created a competing plan, or is they've only submitted their plan?
They've submitted their plan, it's been reviewed, and it meets the appropriate standards for size, taking into account the number of expected occupants and the supporting structures and infrastructure for that size building. It meets the city's needs.
And is that for a high school and a middle school?
The current plan is for a high school. They've indicated and we've made it clear, if you come back to expand the campus, structures on the campus, you would have to meet whatever standards are applicable to that size building. You have to have the right infrastructure. You would have to have enough space for the number of students that are going to be in that building. And so the answer is, until they submit a proposal or plan for expansion, we don't know what that size would be.
Yeah, so what we would say is, we're not writing you a blank check. What you want is what you get now. If you want to avoid a fight in the future, here's the size of your school. This is the size of the school is going to remain. You're going to have to, so I think the size of the school has to, whatever they put in their plan. I'm kind of a little bit frustrated that we didn't submit a competing plan. It's kind of unfortunate, but if they have their plan, then they should be limited to that plan without any expansion for 30 years or something. Right? Then they shouldn't be allowed, for example, if I'm on that side of our residents, I don't want their buses because all of their students come from outside of Duncanville. I don't want their buses parked up against my fence. I don't want them in the morning when they start off to go pick up their thousands of students to make all their money. Their buses parked up against my neighbor's fence before they start at 6 a.m. in the morning. They need to make sure they have a plan where those buses are as far away from the residents as possible. Then they should not be allowed to have third parties participate in or use their facilities for any events, sporting activities, or the like. Yeah.
The Bowie High School in Austin, we lived there for 30 years, in the fight with Sunset Valley. The school now looks like a college campus. They have a 3-tier garage. They have tennis courts. You name it, it's on that high school. So it is essential for us to put some limits on this.
Yeah, because they'll use it as a profit center in our backyard. We don't need Bob Knight's sports facility right behind our house again. This is really serious. This was the first house I ever bought. I bought it in 2008, which tells you that when I bought my house for $413,000 back in 2008, the price of that house went down to $280,000 a year later due to the collapse. I've never captured the gains on my house as in other neighborhoods. And you know, part of the reason why we don't get that is because we don't fight the way other neighborhoods fight. This is a very prosperous, hardworking set of people who work in this neighborhood. And if this neighborhood was in anywhere else, they would be fighting, and they maintain their value of their house so they can give it to their kids and build wealth and generational wealth. And this is a very serious issue to us, and I appreciate everyone on here who is taking the heat to be named in a lawsuit, which you're not going to have to pay for, because that rarely, if ever, happens. I've done this 20-something years. They never collect under those circumstances. But my point is this. If you're going to come in here and tell me that you're walking in tomorrow to tell the judge that we're close to a settlement, the people you purport to represent are telling you, no, here's some other bullet points that better well be in this settlement agreement, or at least strongly negotiated, to something close to it in the it should agreement ever be reached. So that third party usage is a big deal. The limitation on size is a big deal. The location of the buses, wherever they're going to put them, is a big deal. And zero ability to expand for some significant period of time. And I'm talking decades. And that's all within the power of the city council.
What else? What else?
Yeah, give us a minute. Just give us a minute. I mean, you're kind of putting this on us.
I just would like to say one more thing about the city council that represents our city council, Mr. Davis, and all of the other city council members there. I want to know, is it possible when you go into executive session and you make that decision, will we know how you voted? Will we know if you voted yay or nay? Will we know what your position was? Because that's going to be important to us as residents of the community that you did not stand with us. That's going to be important to us when we go to the poll to say that they didn't listen to our community. So we will know who votes what, right? We'll know who votes.
Any action that's taken
Pardon me?
tonight, any action that will be taken tonight will be done in public.
Okay, so we'll know who voted
Yes.
what. Thank you.
All right. So you asked for something else, which I feel like it's very inappropriate to ask us at the 9th hour for a list of things. This should have been done months ago. However, I think that because we live in Daniel Films, so right there's a gate. So we need some type of protection or something ongoing because we can't get out our gate. So I think they said they looked at the possibility of a red light, but because there's already we're all within 500 feet, there can't be another red light there or whatever. But I don't want to wake up and try to get to work and can't get out because all these buses and all this extra traffic is in front of our gate and we can't get out to get to, like she said, to get to our respective jobs or schools or whatever. So we need something that could be in place to show there. And I don't know, we need to put a towing sign, you will be towed, but we do not want them blocking that gate because that is the only way in and out of our neighborhood.
Where do you live?
Meadows Daniel Farm. Right on Danieldale. Right. The neighborhood that's going to back up to this monstrosity, basically. Oh, right, where the bus is going to exit. So, yeah, so, hold on.
All right.
I was just adding to her point. That's our gate is right where their exit strategy for all of their traffic.
Right across from the exit from the school district.
Yes, that
property,
they were going to make that right, and coming out that little gate, they're going to make the right, and our gate is right there. And like I said previous, when there's a wreck on the freeway, everybody diverts their traffic, and with the new light, we already can't get out, and the traffic is backed all the way up to Cockrell Hill 67.
Okay.
It's just a two-way street.
I have a question. Thank you guys for listening. Have y'all visited where we live? Have you been out there? Because you could see what Mark is talking about. It makes a square. It's just a square, and then there's a street down the center. And on the back wall, that's where they're trying to build this school. And then on top of that, what they're talking about, when you come out of our gate, if you make a left, then there's a gate that enters into that property where Larry Johnson used to own it, and it goes all the way back. Because I was there when he still owned it. It was a house there. But have you visited over there to see what we're saying? Because if you just go look, you're going to say, wow, I would not want this school back here. Because it is literally, when I say in the backyard, Mark going to have some parties, I'm telling you. Because it's literally, it's just all of that is laying in the back, then on the side, and we're just smushed in. And right now, if you leave and try to go down Daniel Dale to the hospital at 4:30. For the new subdivision that's there, that traffic is backed up all the way to Cockrell Hill.
Okay.
And so now we're going to add all of them. I mean, you just really I empower you to just drive by there in the morning and just see it, and you'll see what we're talking about.
At this point, I'm gonna interject quickly because the new district representative from that neighborhood, who had nothing to do prior to him being elected just recently, but he's had a comment that he's wanted to make for some time, so I'm going to go ahead and allow him to speak for a moment.
I really, my question was directed, thank you, Mr. Mayor. My question just for the record, so it's just, so we're all in the same boat here. Mr. Hager, could you just explain why perhaps some of us may have been included, or just me personally were included in this or not?
Yeah, the people that were included were the people that voted against the zoning. You were not either a member of the council, although you were a member of the P&Z, and only the members of the council made the ultimate decision.
Right.
So only those that voted against the zoning change were named in the lawsuit.
And just to clarify, though, the recommendation of the Planning and Zoning Commission at the time was denial in terms of our recommendation up to this council at that time, correct?
Correct.
Okay, thank you.
Okay, and also I'm going to ask Mr. Jeffries at this point in time to also explain, because it's been mentioned a couple of times, the circumstances that led up to us only having a limited window of an opportunity to come here and speak before you, because I get what your suspicions are. I get what's been said out there, but just to clear the record as to why we ended up with this small window, it really wasn't something that was within our ability to determine on our own. So I'm going to let Mr. Jeffries speak to that.
Thank you, Mayor. In a lawsuit, there is a procedure called a motion for summary judgment. And in a motion for summary judgment, a party is asking the judge to rule in their favor on legal issues in the case without the need for a trial or further proceedings. So a motion for summary judgment was filed in this case against the city on these legal issues that we've talked about. And so we would be, under that proceeding, have to show that the legal issues that we've talked about, the fundamental issue of whether we can keep the school from going at that location, is something that we would have to show that we have a right to keep them from going at that location. They've also asked for the court to rule that they are entitled to the plan that they submitted that was rejected by the city. And again, it would be the city's burden in the case, at this stage of the case and eventually at trial, to show that we had one of the grounds for rejecting the plan that's recognized by law. And those are the primary issues in the motion for summary judgment proceeding. And then the remaining issue, if the case goes forward and the judge rules against the defendants on those legal issues, the remaining issues to decide would be what kind of order is the judge going to issue as far as the plan that would go forward for construction, and potentially what kind of damages would be assessed in favor of Life School and against the defendants. So that motion for summary judgment was filed. I negotiated an extension of the period for responding. Council would understand the new rule, effective on March 1st, gives a very tight window for the courts to resolve those kinds of motions. Motions filed, you get 21 days to respond. The other side gets 7 days after that to reply. The judge has to have a hearing no earlier than 35 days after the motion's filed, and no later than 60 days after the motion's filed, to issue a ruling on these legal issues. So Life School has forced our hand, so to speak. We had been negotiating with Life School at this stage over the plans that had been submitted, and we were asking for some clarification, we were asking for some concessions, and we've gotten clarification. We've gotten some concessions, again, subject to final blessing of the council on what we do at this stage of the case. But we have a very tight window to get this addressed and resolved. And the legal issues, as Mr. Hager has pointed out, are a tough fight to fight. And so the thought is, because the city has already put in the process and accomplished review of a lot of the plans, including going to the expense of getting an independent traffic study done, having outside consultants look at the plan submission to make sure that it meets the requirements for health and safety issues and structural issues. That's already been partially accomplished, and again, Life School has met the requirements of almost everything that was previously raised as a concern, and then they gave some concessions on matters that they didn't have to give concessions on. And so the thought is, pardon me, the thought is that rather than have a judge rule against the defendants on these legal issues that are, I think, well settled in the law, and then the judge is left with the possibility of just simply ruling on the remainder of the case by trial, which would be the damage issues and injunction issues, the thought was, well, let's see if we can wrap up negotiation and get an agreement as to the plans that would be used to go forward with them complying with the city's permitting standards and requirements for construction, and use a defined set of plans to get the project built. And the plans that have been submitted, including the traffic study, the traffic mitigation or traffic management plan, all of the issues that had been raised about height, size, location of facilities on the property, issues regarding the stadium, the request for screening procedures or standards. Life School has addressed all of that. Life School has met what our own experts indicate are the standards that we would want to enforce. So if we came up with a plan and it has to take into account what Life School is entitled under the law to get on the property, I'm not sure what that plan would be different than what we have worked through and are on the brink of trying to bring to a conclusion. So that's where we are. That's the reason for a tight window of getting something done, or else we have the very likely chance somebody's going to decide for us and decide it without any concessions, decide it without any of the clarification that we sought and obtained. So that's where we are. No, I've gotten an extension to the response deadline with the idea that we would have, currently it would be the first week of July. I don't have the exact date in my head, but it would fall due in early July to be decided on or about this, I think, July 17. And again, depending on the judge's availability and schedule. But we got an agreed postponement of the procedures because of the negotiating we had been having, and because Life School had all in the litigation process addressed the concerns that had been raised at the time their plans were submitted to the city a year ago.
Mr. Council, Mayor, you mentioned one thing. You mentioned that newly elected Councilmember Davis, who I voted for. Oh, you didn't have any votes, right? I'm sorry. Who I voted for, however, did have seen the property. Mayor Pro Tem Gooden have seen the property. Mayor Gutierrez have seen the property. I'd like to make a recommendation, Mayor, and it's because the city attorney keeps asking us, what do we want? I'd like to make a recommendation that we adjourn for 15 minutes, give us 2 flip charts, and let us, since we are pressed against the wall, give us 2 flip charts and allow this body to come back with you of what we're asking for you to ask for us on our behalf. So that's my recommendation. I know we have to roll up our sleeves because we don't have tomorrow to do this. I'm just asking if everybody would consider be appropriate for with a 15-minute recess, giving us 2 flip charts, something to write with, and let us come back and we can answer the questions, City Attorney Hager, to what we're asking for to an exemption.
And were they gonna answer? I was waiting. And well, while y'all deliberating, I heard you say that Councilmember Davis is being sued because he wasn't in his position.
No.
Oh, he's not. Okay, I'm sorry. But you also said that the others are being sued because they voted against the zoning change. I'm going back to the zoning change. I know we fighting for what we don't want or whatever, but I'm going back to the zoning change because when I mentioned it earlier, you guys said that schools that we did not vote for a zoning change and that schools can do what they want. And I did Google research, whatever. No, I'm not a lawyer, but it says Dallas ISD tried to build a school facility without following the city's zoning process. They claimed that they were a school district and therefore didn't have to follow the schooling zone. The city of Addison said you must follow zoning like everyone else. The court agreed with the city of Addison. The court ruled school districts do not have automatic immunity from city zoning laws. The court said schools must follow zoning unless legislature clearly says otherwise. The legislature has never said schools can ignore zoning. The final result from that case was Dallas ISD could not build until they complied with zoning. The city had the right to regulate where the school could be built. The schools must follow zoning just like any other land use. So my question is, what is the legislation that that you guys are saying that life has immunity to build on a single family property?
Well, there's many aspects to zoning. Okay, so I don't expect that we'll be able to go through all the aspects of zoning, but zoning, let me finish, please. Let me finish.
Yes, sir. Go
Zoning is, to the extent that the attorneys have explained tonight about lighting, about the stadium, about a number of other things, is distinctly different in this case than zoning that you're talking about, and that's being that this is the residential zoning nature of this property. They're distinctly different zoning discussions.
Mm-hmm.
Okay, so you have to understand that because we can't mix the two.
Right.
That makes my case right there.
Correct. So what I was going to say is that it also stated that the Dallas ISD they only had 2 options: to change the zoning or either get an SPU. When we first came, it was changing the zoning. Then they came back because they wanted to get a special SPU from the city. So my question is, now we approved the SPU for the Life School because based on Addison, the city of Addison, and Dallas ISD, which is a large, huge school district that has a whole lot more money than Life Charter School. How is that case different from ours? How is that case different from ours as opposed to zoning? Because originally, I'm going back, we were voting to change the zoning from single family to commercial. That's what now I don't know if you, but someone just said, Congressman Davis was not being sued, but he did vote against changing the zoning. Is that not what we just said? Mr. Davis, Councilman Davis, were you excluded because you did not, or excuse me, you voted against down life school changing from school zone, single family to commercial?
So thank you for the question. I was not, as I think we were previously advised by our city attorney, I wasn't mentioned in this particular litigation because I wasn't in this capacity at that time. I think it's important to bear in mind that a planning and zoning commission, all 7 of its members simply make a recommendation up to the council, but the final ability to pass a piece of ordinance that would facilitate this application and everything we've been discussing now for about 3 hours is related to making sure that this body would make that decision, and I wasn't yet here. It was the recommendation of the City Plan Commission to deny that zoning application in the form. One moment, in the form that it was in. This body since took that under their advisement, and they made a decision similarly, quite frankly, to the decision of the city council. And now we find ourselves this evening in the situation legally what we're faced for. I really think, if I can just give you my two cents, is that we really take a hard opportunity to roll our sleeves up here, and you all be able to put down the things that you still have concerns about, or the things that you would like for our city attorney and the legal team to take under advisement and be able to bring to the table that further express your concerns, and as a measure to safeguard you from what you fear this particular development opportunity would bring to bear as it relates to your quality of life. And so that's what I would really encourage us to do and to think about, given that, I hate to say it this way, but the horse is out of the barn. And so if there's still some unaddressed concerns, and given the timing and the sequence of this, I think that I would really encourage the better use of time would be to talk about what are those things that you still are concerned about that are a part of this versus the other. I know that we've had some mention, and I'm going to take just a couple little liberties if you don't mind, Mr. Mayor. I know that we've had some discussion about where buses are located and certain things as it relates. And so I don't know, Mr. Manager, if there's an opportunity to be able to equip folk here with what are some of the things that are on paper today in terms of what that zoning, because folk could probably slip and doesn't have that right at their fingertips, even to best utilize their 15 minutes. So I think that's one component. And also additionally, Mr. Manager, something by way of a site plan so they can be able to see, so neighbors can be able to see where things currently are laid out on the site, to the extent it addresses concerns about where buses will be queued, stored, and otherwise put into motion each day. And so, I mean, because some of that hasn't changed in the zoning application, I think, from its inception, and so it may be helpful just by use of the short truncated window that these neighbors have an opportunity to give that feedback to us and to this legal team. Thank you.
Assistant City Manager Rauscher is going to put a couple of pictures up on the screen so everybody can see the layout out there. And I will tell you that we did get a consensus up here a few minutes ago to recess for 15 minutes or so. We're not going to put a time clock on it, but within reason, so that you can gather and maybe come up with that list that you had mentioned. All right, so we're going to go ahead and do that right now since we're right up on the 8 o'clock hour. Is that enough time, sir, for you to do that? Okay. All right.
Okay. Is the mic off? Can y'all hear me? Oh.
Once they produce the
Okay, and with that, we have a quorum. We're not quite ready to get started, but I am going to go ahead and resume our regular meeting at 8:20.
Thank you, Mayor. Thank you, council members.
We'll go ahead, as soon as the attorney gets back, we'll go ahead and actually, there he is.
Yes, this list is really for him.
All right, Mr. Hager, we're back in session now.
All right.
And we're going to hear the summary of thoughts they want us to pass on to the
Life School?
tomorrow to the Life School folks. And City Secretary, you prepared to keep the notes on this? Okay. All right, let's go ahead and begin.
Okay, so we were asked as the constituents of this neighborhood to, as you stated, make a list that we think are appropriate to make as part of a settlement agreement. The first demand we'd like to make is no usage of this property by third parties. I think that restriction means no usage of, for example, AAU basketball, private entities of this facility as tenants or temporary renters of this facility. Our concern is that because apparently we're subject to a school being able to just declare itself a school and then invite anybody they want to and create a stadium there, and then if it's also the case that then they can invite people every week to rent that facility out, we think we're still in a position where we can argue, or at least seek some serious restrictions on how often they have events at this facility, and we can limit it to only events directly with the direct participation of the owner of the facility, in this case, Life Schools.
All right.
So that's really important to us. We don't want 50 weeks of events every year at this facility. Then we believe it's also appropriate to limit the size of this facility to its current plan. I think that's a reasonable ask as well. I think listening to Mr. Hagar, that's also within the power of the council to limit the current size of this facility.
Well, let's be clear by getting confirmation on that from Mr. Hager.
Yeah, I think that there's two phases, and I think what he's saying, any expansion over what's shown on the site plan would require a PD amendment.
Okay.
Right.
All right.
Well, I think what I'm also saying is, and let me be very clear, that they need to write in a restrict. We would ask for an actual restriction, an express agreement not to expand beyond this current plan for 30 years.
I think you could, I'll be honest with you, I think you could ask for it, but if it's the state of Texas, it's probably unenforceable.
Well, it would only be enforceable as to this owner. I mean, it's a settlement agreement. It's private. You know, you got to write the contract under the Texas
I understand.
Constitution.
I'll ask. I think they will reject that, and I think they'll reject it because they view themselves as being the state of Texas, and I could not get the state of Texas to agree that they would never use public property for an appropriate public purpose. And if you were asked the city to do the same thing, it's probably unenforceable. I don't want there to be a false expectation. I will ask, if they'll agree to a contract, we'll write it in there, but I don't know that that's enforceable.
Well, then what are we prepared to do if they reject this tomorrow? Are you guys prepared to file a response to their motion for summary judgment?
You know, I've asked the lawyer that's responsible for that, not me.
Are we prepared to, would we be prepared to file a response to their motion for summary judgment and create some sort of fact issue that we could at least gain some leverage where we could say, hey, we're going to trial. Maybe you guys should agree to some of our requests. Is that an actual possibility?
Short answer is I can prepare a response to the motion for summary judgment. How successful it would be is going to be up to the judge, and I don't see a lot of prospect in challenging the motion as presented because it's only legal issues about. The motion as presented only addresses legal issues as far as can we restrict the life school from going at this location, and what restrictions the city has asked for, do we have the right to ask for more, and essentially is life school's plan as presented something that we can challenge? And the short answer is I think that would be very difficult to succeed on. The remaining issues would be subject to trial. So the motion as presented is really on the fundamental legal issues in the case, and I don't know that there's a fact issue you can raise on those legal issues.
Even as it relates to the second issue you mentioned in terms of the right of the city to at least modify the plan?
So the right of the city to modify the plan, the burden would be on the city to show a basis for doing so related to health or safety issues, and or a nuisance issue, which is tied in
Or
with health and
unreasonableness,
safety.
right?
Yeah, unreasonableness.
And so unreasonableness usually is a fact question.
Well,
are we not prepared to, could we not be prepared to present either expert testimony or surveys from the residents or some sort of evidence to create a fact question is what I'm asking. I mean, we're prepared to help and assist in any way to create a fact question when you say that the response isn't even due until July. And I'm merely suggesting this in order to, because this is how litigation works. I'm just explaining, I know you understand this. We can gain some leverage in negotiating what we want if we fight back. And if we tell them that we're just going to lay down, then of course they're going to say, hey, thanks, this is what we're going to do. We'll give you an update when we want to do more. And that's not what we want. If we have an opportunity to restrict them now through an agreement, that's what we would prefer to do. And it's well within the budget to do a response to a summary judgment.
And the short answer is, if I don't get direction to bring this to a conclusion, I will file an appropriate motion for summary judgment. I will be, okay. If I don't get direction to, okay. If I don't get direction to bring this to an agreed conclusion, I will file a motion for summary judgment. I am not optimistic that I can succeed in the motion for summary judgment that is presented, which it challenges mainly the legal issues of whether the city can carry its burden of showing that the city is acting to deny the life school plan based on health or safety issues.
You're going to be entitled to a hearing, right?
Yes.
When would that hearing take place?
Well, it hadn't been set. Yes. Sometime before mid-July or around mid-July.
Around mid-July.
Yes.
And I've been in front of Judge Tillery, and I've been in front of a lot of these judges. they are not inclined to grant motions for summary judgment under most circumstances. Now, I understand that this is a pure legal issue to some extent. I would kind of disagree with that. But I believe that if we were to show up and show interest in this case at a summary judgment hearing, a judge like Judge Tillery, who I'm familiar with, would likely find a fact issue and say, we're going to trial. And we would at least defeat their motion on its face and get to trial and have some leverage, whatever little it is, to get some concessions from them. Now, this is really important to the people who have invested a bulk of their income in building this neighborhood. I mean, this is really important. That's all we're saying. And so we would like aggressive representation under these circumstances. And I think that's all we're asking, which to me includes, and very likely includes, at a minimum, a filing of a motion, a response to their motion for summary judgment. That's what you guys can decide. I'm
Okay.
just telling you, that's what I would do under these circumstances. Let me finish the list. So the first one, limit usage to third parties. No usage by third parties, private parties. Limit size to current plan for at least 30 years. Then as far as under the category of noise restrictions, no outdoor activities after 5, no outdoor activities on weekends, no PA systems in usage after 5 p.m., and a better plan for more mature trees in order to block out noise. And we would ask for a setback of 50 feet as opposed to 10. These are our ask. On all the roads, so if you look on the plan, you have the roads, you have the basketball courts, you have the parking lot. We want any actual construction or development to be 50 feet away from the actual subdivision, as opposed to 10 feet. The road, yes, and as well as this road. Yeah, and I haven't, and I'll get to the fence. And then this parking lot, at least the corner appears to get fairly close to the subdivision. And any roads exiting or entering into the facility should also be at least 50 feet away from the fence of the residents of the subdivision. Well, the property line and the fence are effectively the same thing, is my understanding. Well, then the fence. Okay, then the fence. I think the fence is fine.
Yeah, I think that measure is fence, because when I look at
I haven't mentioned the height of the fence yet. Setbacks are for any developed portions of the property. For example, the roads, the ingress the actual constructed roads, the parking lot, the practice facilities, as well as, do we want the fence 50 feet away? Yeah.
Okay, let's keep
And
going.
then, I'm almost finished. If there's any way to offer a plan in which the stadium is set further back, or, go ahead.
We really want to move the stadium from the original drawing. I don't know if you recall, the original drawing was over on the DeSoto side. So if we can move that back on that side versus being behind the Bradley Street, which is the back street.
I will tell you that I asked
Because it's what?
Floodplain.
They'll initially move it though.
Yeah, they did at one time.
And they moved it back.
I assume that's a floodplain. I would,
I'll just let you know I asked, but I'll ask.
okay.
Okay.
Maybe not that spot, somewhere else.
And then as, oh, and then with regard to the fence, a 15-foot fence or a wall as opposed to a 8-foot wall. And then,
Did we have on that, the band practice before?
oh yeah, and then under noise restrictions as well, no band rehearsal before 7 a.m. Or after 8 p.m. Then I think there's one more thing.
City traffic control
I'm sorry.
cop.
And then we want a traffic cop at this entrance on Daniel.
Coming into the gate.
Yeah, coming in and out of the gate. Relevant, time periods. The Daniel Dale exit.
It's only one way in and one way out of our gate.
That's Duncanville and
No,
They go straight over into the neighborhood. I don't know what it's called.
You can see it on the map here. Now, the corner, this map doesn't show the corner of Daniel Dale and Cockrell Hill. And that's our list.
Okay.
Once again, if I can just add, I think it would behoove the city to make a fulsome effort to at least posture as strongly as possible for a negotiated settlement. I think the only way you can secure that negotiated settlement with any significant concessions would be to put a fear in life schools that there are actual opportunities to win this case. One of the ways this case could be won is simply filing, in my opinion, as part of a motion, a response to their motion for summary judgment, would be a demand to compel arbitration. I also think if there's still time, if we can come up with some sort of rebuttal plan, I don't know what you call it, a city's own plan. I think you put Judge Tillery or an arbitrator in a situation where they could at least say they split the baby and with the city's plans under these circumstances, which is often what occurs under these circumstances, in which a judge knows he can't outright side, at least according to you guys, can't outright side with the city, but he would, under most circumstances, a judge or an arbitrator would be willing to enter into a compromise plan if we so presented one. And, that's my legal advice if I was handling this case. I would also, if necessary, I know you guys have already sought a continuance, but I am still somewhat confused that we hired a traffic expert who didn't find in our favor that the traffic caused by this facility would have been more detrimental. If I'm paying an expert to have an opinion, they would have had an opinion that more closely aligned with what I want. So, those are my 2 cents.
All right, thank you.
Thank you.
Okay, at this point, we're going to move on to item 1, citizen input. As I said earlier, some of you may have spoken in lieu of, if you've filled out a card. City Secretary, how many cards do we have? Okay, well, let's just go ahead and call out the names. If they're still here and you still want to come up, remember the rules of citizen input are to identify yourself by name and address, and then you have 2 minutes. At the end of that 2 minutes, your speaking time is over, and the council cannot respond to any questions or address any issues you brought up. So it's strictly limited to you making a comment or comments for 2 minutes. So let's go ahead and read the names one at a time and see who's still here and who wants to talk.
Okay. Alicia Brown Young. Okay. Dr. Simmons.
And I think everything has been covered already.
Your name and address, please.
Excuse me?
Name and address.
Dr. Simmons. I live on 939 Fairway Drive.
Okay. Thank you.
The only thing that bothers me, beside the noise, we have all these ambulances coming through. Is Life School going to make any allowance? How is the ambulance going to get rerouted to the hospital? This is people's life. What is the council doing about this situation? See, I live close to to Kakri Hill, so I know what goes on the street. This is very serious. They come from Red Oak, DeSoto, and these are our neighbors. I think for now, that's all I'm going to say. You know, our back is against the wall. I can imagine the noise. Even if you put a razor wire on top of the wall, it's going to go through. We don't have a choice. But people's lives are at stake here. Our neighbors, our friends. I'm a physician at Charlton. This is not a good issue.
Thank you.
Okay. Dr. Nisa Sasser.
Good evening. Nisa Sasser, Hartford, 1531 MacArthur Drive, Duncanville, Texas. Just I'm not going to go through the spiel that I had originally prepared because of everything that's happened tonight, but I did want to make you all privy, if you don't already know, about also the apartments that are planned for the corner of Bolton Boone and Daniel Dale. I don't know if you all, I know this in DeSoto, but since we were talking about Charlton Methodist, I wanted to bring that up because it will heavily impact traffic as well once those apartments are there. So wanted to just make note of that. Thank you.
Thank you.
Steve Madison.
I'm Steve Madison, 514 Shelley Court, Duncanville, about a mile north of or west of that site. I've been listening to you folks. I didn't actually understand how bad this was. This is a terrible site plan. I'm a registered architect in the state of Texas. I've been doing this work for over 40 years. I'm also a land broker with Century 21. I don't think you should fight this. I think you should partner with them. I think you should use the resources of the Duncanville Community and Economic Development Corporation, which I served 6 years on from 2000 to 2006, to partner with them and enhance this project. Hire your own consulting architect that would redesign this thing so that having that stadium and that location is a terrible idea, horrible idea. Would never do that. You can redesign this thing. $100 million construction project in the city of Duncanville is a tremendous opportunity for economic development. I don't believe there is another $100 million project ever in the city. I've been lived here 28 years. Maybe the high school might have been $25 or $30 million. Okay, 41 seconds. Don't fight it. Get it out of the courts. Partner with them. Use the resources of the Economic Development Corporation. Make them a good neighbor. God bless you.
Thank you.
Mark Cooks.
Mark Cooks, 1106 Bradley Drive, Duncanville, Texas. Can't hear me, right?
No.
That's how I'm gonna feel when I'm in my living room trying to hear what's going on. I'm not gonna be able to hear. All right, Mark Cooks, 1106 Bradley Drive, Duncanville, Texas. Thank you, Mayor and Council, for your patience in listening tonight, City Attorney, and for those that we've talked very strongly to about our feelings. I just want to stand to remind you that this is not about the school for me. This is about the stadium. So we're not losing focus on, we know that the school, and I've already said this from day one, being a previous charter school president in an Oak Cliff location, working on the bond committee for Duncanville ISD, from being a banker who says, oh, we can't get our funding of bonding if we lower the school amount, that we take the stadium away. All of that is not true based upon my experience, direct experience of having this. So I just want to go on the record to say again, this is not about Life Charter School for me. It is about putting a stadium in our backyard. Please help us, council, by listening to what we just talked about and seeing if you really, to his point, sit down and talk this through. Just like when I got on the council in 2012, the first item I had was to settle a lawsuit for railroad crossing. That was a project that they were suing the city. Myself and another council member saw that through, and now we have Wheatland Plaza because of it. Also, the last one I had was a restaurant that the city was suing. I was able to sit down across the table. That restaurant is still here today because we sit down and we worked both sides to make it work. I'm simply asking you and our attorneys to do the same for this project. Thank you very much.
Thank you.
Jonice Preston. Eris Preston. and James Tector. No? That's all the ones I have.
Yeah. So that would conclude our citizens' input portion. And with that, we will recess into executive session. We will recess this portion of our meeting at 8:49 p.m. and move into executive session. Are there some folks out there? Okay. So we're going to resume our regular session at 10:04 p.m. And with that, as a result of the executive session, we have two motions. City Attorney, could you read the first motion? Oh, where is he? Well, Mr. Jeffries, you have them. Okay, with the city attorney back in, he will read our first of two motions. Yes. How's that? All right. Oh, okay. As a result of executive session, we have two motions that the city attorney will read to us, starting with the first motion.
All right, thank you, Mayor and Council. As a result of the executive session, I would ask Council to consider the following motion. Authorize the mayor to sign a settlement agreement once final plans, and I'll list those plans out, have been reviewed and approved by the city manager and staff as appropriate for the permitting application process. Those would include the full set of civil and building plans for the proposed high school and junior high or middle school, filing and approval of the plat as required by the subdivision ordinance, approval of the fire lane plan, which is required by city ordinances and code, landscaping plan, which is required by our zoning ordinance, building an architectural set of plans, which were required by all of our relevant building codes and fire codes, a traffic signal plan for the mitigation on Daniel Dale and Cockrell Hill as submitted and approved and reviewed by our own traffic consultant, a traffic management plan for the interior circulation and operation of the queuing and student pickup and drop-off and use of the facility during operating hours, and the site plan, which we've alluded to this evening during the open meeting. After approval of those plans and after those 7 items that were requested by our citizens be included, we will make the request of Life School prior to signing. We cannot make any commitment that they'll approve them, but we will ask the following: that no non-school licensees or lessees be able to use the property except for Life School in direct connection with the operation of the high school, middle school, or its athletic endeavors. That the size of the facility be permanently limited for a period of time not to exceed 30 years for the size of the facilities past the high school and middle school. That there be noise reduction after 5 p.m. and no earlier than 4 p.m. on each weekday and Saturday. That more mature or larger trees be planted on site and revise the landscaping plan accordingly on the south side of the property, adjacent to, I guess, the neighborhood on the south and east side. The fence screening wall, instead of 8 feet, be increased to 15 feet excuse me, no band or outdoor musical productions before 7 a.m. or after 8 p.m. except for during high school football events. I think the traffic cop request has been integrated into the traffic management plans, and there's no need to include that. And then finally, that the traffic management plan for site be revised to include athletic events prior to the occupation of phase 2, which is the middle school. And those are the items that were asked to be included. And then after the settlement agreement and presented to the judge, and after the approval of one, I'll have another motion to make.
Thank you. Mr. McBurnett, your lights on?
I was going to go ahead and make the motion to approve.
Okay, we have a motion to approve by Councilman McBurnett, a second by Councilman Pennebaker. Please vote. Thank you.
As a result of the motion, Mayor, what was the record of the vote?
Unanimous.
Thank you. Next on the, because I couldn't turn around because I actually hurt my neck yesterday. So the next motion that I would like for you to consider is a motion to direct our attorney through TML, Jim Jeffries, to conclude the case pursuant to the settlement agreement as read into the record with the items that were included and approval of the plans, and present the judge in the 134th, which is presiding judge where this case is currently pending, with the appropriate settlement agreement, including the final plans as read into the record, which would include those things that I previously mentioned, and the request by the citizens, if agreed to by Life School, and approve the city and after approval by the city manager and staff to verify the authenticity of all those documents.
Thank you.
I'll make the motion to approve.
Okay, motion to approve by Councilman McBurnett. Second by Councilman Pennebaker. Please vote. Okay, just for the record, City Attorney, the vote was 6-1 with Jared Davis opposing the motion. Thank you. That concludes our business for this evening. And we will adjourn our meeting at 10:12 p.m. Thank you all very much.